Please, your lordship. Lordship, I'd like to mention item number 27 and 28, lordship. Regarding item number 27, lordship, LCR was called for, lordship, it was not received, lordship. So let the matter be listed next week, lordship. It's from Kamrup district, lordship.
Okay.
And regarding lordship 28, lordship, here lordship, case study has not come, lordship. So may I pray, lordship, I'm on interim, though regular bill, I'm on interim, lordship. Let the matter be come up on next week, lordship.
Next. 27 also interim is there.
No, lordship, 27 interim.
27 case diary.
LCR, lordship.
Can TCR not yet received? List next week.
Date may be fixed, lordship.
Next week. Suggested date.
Service completed, my learned.
Pilot, I am appearing for respondent number 2.
Okay.
Yes. On 28.
Next-
23rd.
23rd, 2310 or 22 the case diary not yet received. Issue reminder. List on 23 same date.
Yes.
Interim may continue, lordship.
28 of the interim bill granted by order dated so and so. It stands extended till the next date of list.
May it please use your lordship. My lord, I may be allowed to bring on record the additional affidavit in respect of item number 46, my lord.
No problem.
May I please your lordship? Lordship, I beg to mention for listing of a bail application. Already item number 40, that is similar bail application arisen out of this same FIR. My bail application may be clubbed with the today lordship.
Elected. No.
Yes, highly obliged. Lordship.
May I please, your lordship? I beg to mention item number 44, lordship.
44.
I have CD not received, lordship.
Okay.
Kindly have a short date, lordship.
44, my lord.
Case diary 44.
44,
Equal later.
my lord.
Case diary not yet received.
Not
To
yet
reminder. Interim is there.
No, lord.
Interim is not there.
On
And that is the fixed list on
24.
24. Interim is also not there.
There on
Oh, is it okay? 24? 2410.
May I please, your lordship? I beg to mention item number 16 here. Motion matter. Engaged council RD is out of session for today.
Today?
My lord, can it be on Wednesday only?
Sure.
Is on item number 16.
16.
Lordship,
Adjourn for the day and fix on Wednesday. Next, 15. No problem.
Obliged.
Lordship, I want to beg item number 20 and 48.
Just a
Per-
minute. 20 and
20,
48.
20 and 48.
Mhm.
As per the instruction of the clients, I want to withdraw this both the
Oh, sorry,
cases.
both the cases.
Yes.
Your
Both the parties have filed already mutual
No,
divorce.
that's okay. Your good name, please.
MD.
MD, Learned Council. 20, order. Learned Council submits that upon instructions, she has instructions to seek withdrawal of the matter. Full stop. The prayer is allowed and the case disposed of upon withdrawal. Let us cross check the number ones, 20 and
48.
48 is for orders. 20 and 48. Okay.
Obliged. May it please your lordship? I beg for listing the matter, lordship. Any Friday, lordship.
Is it a new
matter? We have,
Is it a new matter?
lordship.
Is it a new matter? New matter,
New.
right? I think you'll have to mention before the senior bench. Mention it. Tomorrow you can mention since you want on Friday.
May I please, your lordship? Item 47, lordship. I filed an IO on 9th, but it's not shown in the record, so I seek your permission.
Bring it on record.
Yes,
Okay.
lordship. All right.
My lord, item number 47, with all respect, my lord,
Mhm.
as he has paid, we'll be also filing an affidavit.
Okay.
No interim was granted because he has got 7 and 8 cases, 11 cases, my lord, that we led. Can it come, my lord, after a week or like that, my lord, any day?
May it please, my lords, I am also appearing in this case. My lord, so far the cases that they have projected, in all of the cases, I have been given a final report. I've been
Not
acquitted, my
best.
lord. Therefore, that is not a correct statement. Therefore, my lord, I am suffering from renal failure. I need an urgent kidney transplant. I am hospitalized. Therefore, my lord, 1 week would be too much for us. So I pray that hearing may be done today.
You are appearing for
I am appearing for the petitioner, Your Honor.
petition and.
Yes. He is for
My
the
lord, I am for
informant.
my lord, it's not like that. Is my lord, the arguments are not necessary at the moment, my lord. What I am saying, my lord, with all respect and full adherence, my lord, we'll be filing an affidavit Let it come any day, not today, my lord. It cannot come, my lord, because there are 11 cases, whether acquitted or not, that will prove his resume and antecedents, my lord.
My lord, with
Those are a
deepest
must,
respect-
my lord. No argument at this stage, but this is my
Wednesday,
prayer.
Wednesday or Thursday, is it okay?
My-
Wednesday,
My lord,
Thursday?
we have filed a IA wherein we have annexed all the orders, which shows that I've been acquitted. Therefore, nothing further remains. And my lord, at this stage, if my lord is not inclined to give a final hearing, at least on the interim prayer, my lord, because I'm hospitalized. and
Interim
I've been-
rejected on the earlier occasion, my lord.
It has
That
not,
order may be read, my lord.
that is why the case diary was called for, my lord. My lord will kindly peruse the case diary and see if
I
an
don't
interim
know how
case is made.
arguments come in.
Because my lord, I am hospitalized and the police is hounding me.
He is in
Some
Nagaland, my
interim
lord,
action,
and
my lord.
hobnobbing with I am, my lord. We'll file in that our affidavit also, my lord.
My lord, if only the interim can be considered, looking at the case
In
records.
that case, we'll have to take it up at the time.
Yes,
of
my
the
lord.
hearing. Should we take it up in the normal course or day after tomorrow? Is it okay for you?
My lord, my lord.
Then I'm asking learned counsel, day after tomorrow?
My lord,
Only 1 day? Or
if-
tomorrow?
tomorrow, my lord, yes,
Yes, the
tomorrow.
Difficulty today, you know? It's up to you, actually. I can take it up today also. I can take it up tomorrow or day after also.
Actually, my lord, there's,
On the last occasion, my lord, interim was sought for on the same ground, and the order is a speaking order. In fact, there in the order first, my lord, with all respect, my lord, if you lordship peruses the order, it is apparent, my lord, that in the event of his arrest, he should be provided with treatment, as if arrest has been directed, my
my
lord.
lord, there were certain errors that had crept
No,
in
this is
that
not the matter.
order.
We will argue at the time of argument, my lord. We are seeking time. Let it come upon Wednesday, my lord, with all respect, as your lordship has said, my lord. With all respect and full evidence, my lord.
Very well, my lord, done. Wednesday. Let him also have the satisfaction.
So not my satisfaction, court satisfaction. Talk like a gentleman.
My lord, I
Yeah,
have already,
Not my satisfaction also. I'm willing to take it
My
up
lord,
today also.
Wednesday.
yes, my lord.
But it seems that both of you have some, something or the other. So let's have a
My lord, I'm sorry,
Yeah.
but
middle ground.
Ah.
Wednesday.
Very, very well, my lord. I'm obliged.
Only
I may
1
have
day.
said in a different manner, my lord, lordship would not take it otherwise.
It's okay. No.
I'm so
Let
obliged.
junior counsel appearing for R2, small number 2, appears, seeks an adjournment for the day. The petitioner counsel, learned counsel for the petitioner submits that there is some urgency and prayer submits that even if the prayer is allowed, a short date may be fixed. List the matter on 15/10, right?
Highly obliged.
I'm so obliged.
Highly
my lord.
obliged. Highly obliged.
And we'll see properly.
Yes,
whatever
my
is
lord.
there.
I'm obliged.
May I please, your lordship? Lordship, I beg to mention item number 33, lordship. Kindly pass over for the day, lordship. City is not received, lordship.
33, adjourn for the day. Case diary is not received, issue remind. Right?
Obliged.
May I please, your lordships, 43 3 application lordships. Section 4 of the POCTO Act lordships, 90 days today is 90 days lordships.
But your lordship may kindly take after some time. I am trying to get the instruction regarding filing of such statement.
Today is 90 days.
90 days.
On the date of first remand.
Lordships.
Okay, but your right will start, of course, after 5 PM today, but you take.
Yes,
instructions.
ma'am, after some.
Almost
Now,
today.
like, lordship.
We'll take it up after. Or or at 2 maybe. At 2?
May I please, your lordship? Lordship, intermediate quantity of suspected contraband
Yes.
ganja has been recovered, lordship. 34 days today it is. And case diary may be called for, 60
Yeah.
days offense, accordingly.
Your good name, please?
D Medi, lordship.
G. Mary, learned counsel. Heard, sir. Call for the case diary of Guwahati GRPS case number 142 of 2020. The accused was arrested on 9/9/25. List on
On 29/10.
29.
29, my lord. Now. October 20, on 31/10, NDPS already. 30.
Let it be on 29,
Or 20.
29/10.
20.
Deeply obliged. May I please, your lordship? My lord, here is a case, my lord. My lord, the petitioner is entitled to default bail, my lord. In fact, that has been rejected by the learned court below, my lord. On the ground that, my lord, the investigation has been extended, my lord. Your lordship, will-
Extended.
yes, yes. Your lordship will kindly come to the, my lord, order whereby, my lord, my lord,
Yeah. tell me.
investigation has been extended, my lord.
Oh.
Meaning thereby the detention has been extended.
Mhm.
And in fact, that is on the basis of an application of the IO. In fact, that is not the mandate. The mandate is, my lord, your lordship is aware, proviso to, my lord, subsection 4 of section 36A of the NDPS Act, where, my lord, it has been laid down that, my lord, for extension of detention, my lord, there must be my lord, report of the public prosecutor, my lord. So here in this case, my lord, without any report of the public prosecutor, only basis of an application of the investigating officer, this is extended. And that too, my lord, after 180 days, my lord, that is the mandatory period, my lord. So in that way, my lord, I am entitled to the default bail because, my lord, my lord, detention period expires on, my lord, 24th of June, my lord.
Okay.
Your lordship will kindly
Ah.
come to page 22.
Just a minute, I'm just refreshing with the proviso. once.
Yes, yes.
Yeah, that's,
Uh,
these are the same principles which are applicable to other
Yes, yes.
extensions also.
yes.
UAPA also has the same.
Yes,
The
yes.
public
Yeah,
procedure.
yes, my lord,
that's
the
it.
report of the, his submission is correct, my
Well
lord.
settled that.
Not only on the basis of the report of the IO, my lord, there is one.
IO has to bring
Yes.
the public prosecutor.
Yes.
And public prosecutor, if satisfied.
Yes.
Yes.
Has to
Public,
submit a report.
yes, public prosecutor has to apply his mind and thereafter,
Independent
my-
mind there.
my lord, submit a report. My lord, regarding that aspect, my lord, whether public prosecutor has submitted any report or not, for that, my lord, I will have to. follow for the
Instructions.
Instruction or CD, my lord, otherwise any.
In fact, my lord, it appears that, my lord, this is
Which
not.
is the, you wanted to show me that order? Kindly show me that.
Yes, yes. Your lordship will kindly come to page 22, my lord.
Yes,
This is
I'm on-
apparent.
I'm on 22 only.
Yes, my lord.
It was-
May I read out, my lord?
No, I'll go through. no.
Yes, yes, my lord.
Page given?
Page 20.
22 page na. This is 22 page na.
Can I just-
It is, 17 only is. No, in my petition, my lord, only up to page 17, 22 page is not available. No.
Is it? 22, you'll need 22. It is up to, it is up to 23.
23.
You kindly show him that. So prima facie, this cannot be done actually.
Yes, my lord.
Something which has expired
Yes,
cannot be extended.
yes.
But I think you take an instruction.
Instruction, yes, my lord. Whether my lord, IO has,
You take an instruction regarding this, the IO of the case by report dated. You
I use report, madam.
White report dated.
How
Whether-
IO
whether, my lord,
No,
along with the IO
sometimes,
report.
sometimes the court can also miss,
Yes,
right?
yes,
So
yes.
it appears that there is no report of
Yes,
PP.
yes.
But assuming that, you take an instruction as
Yes,
to whether there was any report of public prosecutor.
yes.
Otherwise, the court itself has mentioned that
Yeah.
statutory period is over.
Yes,
right? So hold on for a day.
yes.
My lord, let him serve a new copy because in my petition only.
I
up
will
to
solve, my lord. I will solve. In fact, my lord, this order is under challenge before this court by way of criminal petition, my lord. And that is fixed on 15, my lord. Your lordship may have this.
Which
together.
order? This order.
Yes, yes, my lord. This is under challenge, my lord.
Okay, both have to be taken up together. then.
Together, my lord.
But it is fixed on?
15th of my lord, day
Oh,
after
that's
tomorrow.
good. We can fix it on
Yes,
same day.
yes.
Heard, this is Bora. The petitioner seeks bail on the ground that statutory period, the applicable statutory period of 180 days was already over when the court granted the prayer of the IO for extension of the same. And that there is also no report of the public prosecutor. Stop. Peruse the order dated 26/6/2025, passed by the learned court below. Stop. It is also submitted that writ petition on the criminal side,
Criminal petition, my lord.
a criminal petition
Yes.
challenging this order.
This
extension,
order,
A
yes.
criminal petition challenging the extension is fixed on 15/10. The learned additional PP, P. Bothagur, shall take instructions regarding regarding the compliance with the, regarding, any report of public prosecutor. Regarding as to whether any report of public prosecutor was placed before the court before this order of 26/6/2025 came to be passed. List on 15/10 along with
Criminal petition number, my lord, criminal petition number 1216 of 2025. And diploma.
May I please, your lordship? Your lordship, at this stage, we would like to withdraw the matter, your
If
lordship.
you want to withdraw.
Withdraw, your lordship.
Learned counsel, seeks to withdraw this matter. The prayer is allowed.
Matter of question.
May I please your lordship? The matter may be taken after some time. Oblige.
Please, your lordships. This is a bail application, lordships. The case has been registered under Arms Act 20 years. Let the case record may be called for, case diary,
Case diary,
and that may be fixed for.
A. Davy, assisted by O. NC.
O.
Poma, learned counsel appearing for the petition. Call for the case diary of Gulogons PS case number 217 of 25. The accused was arrested on 3/9/2025. List.
On 31/10.
31/10. Like 3/9, it'd be a little earlier.
Yes,
than-
On 29,
15,
29.
my lord.
Oh, yes,
Sorry, sorry.
27/10.
Okay.
Please, yes, ma'am, yes,
27/10.
27. Hello, please.
May please your lordship, my lord. Here one typical mistake is in the cost title, my lord, in the district. Then SC
Correct.
NCB, my lord, by hand maybe allow, my lord, and the direction may be given to registry to correct the cost title.
Which is the error?
Error, page number 2, my lord. Petitioner's name of district, my lord. There is Dhubri in place of Kolasip, my lord. And
Oh,
SC
Kolasip is in
SC
Mizoram.
yes, my lord. SC NCB in place of
Ah.
custom, my lord.
Land Council submits and points out that in the cost title, inadvertently, the name of the district is mentioned as Dhubri, though it should be Kolasip
Kolasip.
in state of Mizoram. Full stop. And praise for praise for permission to correct the same by hand.
And my
Prayer-
lord, another, my lord, SC NCB in place of custom, my lord. It should be custom.
It is also pointed out that with regard to the respondent, it should be SC customs instead of SC NCB. The errors are allowed to be corrected by hand. You will do it before registry? What is the procedure?
Registry.
Before the registry.
Registry.
Okay. We list it on Friday.
My lord, same matter is item 8, my lord. Kindly,
Same matter, same kind of mistake.
Out of same FOL, lordship.
Same mistake.
Yes, no. He is representing one accused,
One accused.
7, and I am representing one accused.
Okay.
The NDPS matter, plus,
Okay.
say-
Error is the same.
no, that is.
Different, different is error.
Right,
Okay,
that is my-
no problem. When do you want it, this date after correction? Next, when should I fix it? Friday?
Friday, my lord.
Friday?
Correct.
Friday, Friday, 17. List on 17/10.
Yes, madam. Online.
May I please, lordship, this is the NDPS department, NDPS case, lordship, seized by customs department.
Mhm.
See, case diary may be called for, lordship, now it's just.
Section 21, which?
21 and
subdivision,
29.
Intermediate quantity.
Yes.
Intermediate quantity,
No, it is a commercial quantity.
commercial quantity. 83, call for the case diary of Salamo, Shillong, NDPS, case diary, case number so and so, so and so. The accused was stated to have been arrested on 1/5/25. List on, this can be, you are for the customs,
Custom Department
your
Lodge
customs, your good name,
and Kakoti Lodge.
and Kakoti. And
Lodge.
Kakoti, learned counsel appears. Case diary, when should, any suggested date from both sides?
After 2 weeks, Lordship,
30 or 31, Lordship, 30, 31.
Okay, 31.
obliged Lodge.
Obliged.
31 days.
May I please, Your Worship? This is a regular bail application, Lordship. The petitioner arrested on 2/8/25, today 72 days, Lordship. Your Lordship will find out the FIR on page 11, Lordship. Even though the Lordship, the FIR is registered under POXO, against the present petitioner, Lordship, no any ingredients against him, Lordship, because the petitioner, Lordship, a boy of 19 years old, Lordship, he was working in the house business establishment of the another accused, that is Mohandas. He was the prime accused in this case, Your Lordship. He was just working there. No any allegation against him that he is involved in this case from the FIR, Lordship. Nothing has stated against him, Your Lordship. It's in page 11, Lordship. And forwarding is in page number 13, Lordship. The ground.
Immoral.
Yes, but the present petitioner is a 19 years old boy, Lordship. He was just working in the house of the prime accused Mohandas. It's not name also not in the FIR, Lordship. Today is 72 days, Lordship.
Sagar Das, huh?
Yes, Lordship.
This will require this notice to the
Yes, yes, notice to the respondents. And CD, my lord. Not only one minor girl, there are 3 on the pretext of providing them employment, my lord.
His role will have to be seen from the
Yes,
case diary.
yes,
of
yes,
course.
from this.
So I think we'll have to keep his, I was just checking. If there's nothing against him, then otherwise case diary will be necessary, but to see his role, if any, right?
Yes.
So I think you quickly serve a notice.
Yes.
They will also help
Yes.
serve it.
Yes.
You're Mr.
SR Islam.
S.
SR Islam.
SRS Islam Learned Council, assisted. Your good name?
Saurabh Farooq.
O Farooq, Learned Council, appearing for this. Call for the case diary of Dhupdhara PS case number 37 of 25. Under so and so the accused was arrested on 23/7/2025. The petitioner shall also take steps for
Lordship
notice.
arrested on 2/8/25.
Oh, sorry, 2/8/25.
Yes.
2/8/20. The petitioner shall also take steps for issuance of notice upon the respond number 2. You, it will be through the police station.
Yes.
Notice may be sent through the concerned police station. Then, since we have to see his role, his age is also on the lower side. So 72 days. So let us have a shorter time frame. Next Monday. Next Monday.
Next Monday. 23. Yes, 23. Yes, 23 then.
If notice is called, CD will call the case diary.
Yes.
Call for case diary. It is, no?
23.
CD will come, but
Yes, CD.
notice, if you can,
Yes,
help
23
with the
then.
notice, then
23.
Right.
23.
Case diary will be required, Lordship, intermediate quantity. Only thing is that, Lordship, today is 47, Lordship. 47 days, 60 days of Lordship. Maybe
let
on,
us see the case diary. Hattigaon, it will come quickly.
maybe on 23rd, Lordship.
Just a minute. Mr. Mehdi?
D. Mehdi, Lordship.
D. Mehdi, Learned Counsel. Call for the case diary of Hattigaon PS case 160 of 25. The accused was arrested on 28/8. He was arrested on 28/8. 28/8
Lordship.
or remanded on 28/8. The accused is stated to be in detention since 28/8/2025. Call for the case diary list on, because sometimes, you know,
2310.
taking the date with consultation also helps, because I don't know how many matters will be listed. Right?
24 would be convenient, but on the, if he has some
23, okay.
24,
Lordship, 24.
25th, 25th.
You have problem on 23.
No, it is for my convenience if Honorable Lordship would grant me 23rd, Lordship.
Very.
Wait, please, your lordship. Lordship, this
Go
this is
ahead.
a regular bail application, your lordship. Lordship, trial court record may be called for, your lordship.
It is at the stage of trial already.
Yes, your lordship, charge framed.
Oh, that's very. Counsel, your good name, please.
MD A Rahman, your lordship.
Honored
No,
counsel.
I don't know.
Appears. Call for the scan TCR of special NDPS case number 165/2024 from the Court of the Learned Additional Session Judge number 2, Nagaon. The case is stated to be the stage of trial after consideration of charge, after framing of charge. That's list on. This commercial quantity.
My lord,
For a
on,
proper hearing.
on 2910.
29.
Lordship, highly obliged.
May it please, my lords. My lords, in this matter, may the matter be taken up after some time, my lord. Mr. G. Chaudhary will be moving the matter.
May please, your Lordship, matter may be passed over only for some time, my lord.
May I please, your lordship? My lord, regular bail application, my lord. My lord, intermediate quantity, 1.96 gram of ganja, my lord, recovered. And she was arrested on 25/7/2025, my lord. Today is 78 days behind the bar.
78 days.
I will get the instruction, my lord, regarding.
No,
time.
but commercial it is intermediate quantity, it is 60 days.
60 days, but my lord, regarding probably prior to that, my lord, search sheet submitted, I will get the instruction.
Okay, you, should I fix it tomorrow then?
Tomorrow, yes, at 2
Tomorrow
PM.
or 2? You wanted?
Yes,
2?
at 2, my lord, I will try.
Let us try at 2.
Yes.
If not 10 tomorrow.
Obliged, my lord.
At 2. Not present.
Lordship, in 15.
15, yeah,
15.
take it. No problem, I'll take it. 14, so you have for 14. I'll take a 15 then.
Yes, yes.
Yeah.
Herein, your lordship, a notice was issued, your lordship, to the petitioner, that is at page 15, your lordship, kindly have a look.
Yes, yes, yes.
Page 15.
Page 50. It was issued on 14/8/2025, but the petitioner received it on 10/9/2025. Now the petitioner wants to participate in that proceeding, your lordship.
Telangana.
Yes,
You are seeking
trans-
transit and.
Yes, yes.
So this takes a little bit of time. What is the, because as you know, the Priya Indoria.
yes, 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 I.
No, one of the things that is laid down, of course, you know that, is that, you know, the petitioner, I'll have to justify as
Yes.
to why I am not approaching the jurisdictional court. There has to be a prima facie satisfaction.
In page, in para 7 of my petition, your lordship, page.
So this, otherwise, you know, in a way, in a way, it amounts to usurping someone else's
Yes,
jurisdiction.
yes, yes.
So that has been, window has been given for, the say, interest of liberty. Para?
Para
Eight?
7, Your Lordship, page 6.
Page 6. So we cannot, go beyond
due
that
to-
window, in my humble opinion.
Due to the illness of his mother, Your Lordship.
Actually, I need some guidance actually on this prosecution, because I have seen some orders of coordinate bench also. That, some protection is given, 7 days, 10 days or 15 days, and he can go and approach. In a way, that is better.
Yes.
But, living case,
Yes.
the first condition is that notice has to be issued to that jurisdictional prosecutor and police.
Yes,
That takes time.
that takes time.
That takes time. So if that process takes, it takes more time, and the person is given interim, then in a way it disturbs that jurisdiction,
Yes, my
in my opinion.
otherwise, my lord, only. my
But,
lord,
but that's the stipulation actually.
But herein, Your Lordship, two notices were issued, Your Lordship. In one notice, the
otherwise in-
petitioner has already approached before this Honorable High Court.
In some cases, my lord, only for a particular period, my lord, suppose 15 days, my lord, 30 days times were allowed, and thereafter it is if within that period of time petitioner can go and apply for
No,
anticipation.
but but thing is that if not, no order shall be passed, one of the conditions says.
Yes,
The no order shall be passed without giving notice to the jurisdiction. Can you give a notice to the concerned public prosecutor?
This is not possible, Your
No, no,
Lordship.
because in one case, the council managed to do, otherwise actually will be violating
yes, yes.
this condition.
Otherwise,
You
my
see
lord,
the
there is no other option, my lord, let them, my lord, while go.
No, I can pass an order like that, but I knowingly, I will know that, that the condition will be violated.
Yes, yes. In case of money.
You can issue a notice to the cyber police station, the prosecutor, to the IO of the police station. That's not a problem. But public prosecutor, he may not know.
Yes.
But the problem is that, Your
Can you
Lordship,
help him?
there is no.
Otherwise, it would be difficult for us to, my lord. To, my lord, send notice to that.
The third, the petitioner is seeking the transit anticipatory bail. Full stop. In connection with Telangana Khammam Cyber Crime Police PS case number 30 of 2025 under section so and so. and so. Full stop. The grounds for invoking the said provisions, the said provisions as laid down in the case of Priya Indoria, Silo, is that that the petitioner's mother is under treatment for her ailment, and therefore he cannot go immediately to that police station. He is facing difficulty to go immediately to that police station. Full stop. The petitioner shall take steps for issuance of notice to the jurisdictional IO and the public prosecutor. Now you take steps within a week,
Yes.
then we'll take after this. Right?
But what I'm praying, Your Lordship, a similar matter, Your Lordship, on 16, it was listed. And
On
in that,
16?
yes, in last 16, Your Lordship, it was listed, and in that case, Your Lordship, 1 month time has been given.
No,
To
but notice was given.
No notice, Your Lordship. I will supply that copy, Your Lordship, if Your Lordship will take up this matter at 2.
Yeah,
Then I
good.
will-
But
Yes.
we should also take up.
No, no.
টেবিলতে আছে কৰি আছো। প্ৰিয়া ইন্দোৰিয়া বুলি কৈছো লিখি কৰি। Because I also find that to be convenient, but since we are aware of that provision, how
Yes,
can
yes,
we,
yes, yes.
how can,
I understand.
how can we, or all of us, you also would not suggest that perhaps violate, but coordinate bench. That is in a way convenient.
That order was passed in AV number 23.
Kindly see, because, what are,
Yes.
kindly, both of you see this. We have to learn, from how to apply this.
Yes. So, my lord, first condition is to serve notice to the.
Kindly see. Till the returnable date, in the event of arrest of the petitioner in connection with this case, he may be allowed to go on bail of rupees 25,000 with one surrogate. The satisfaction of the concern, the satisfaction of the arresting authorities, and subject to the condition that he shall render whatever cooperation is necessary to the investigation. So IO is not a problem. Hyderabad, right? No problem. Cyber, well developed. But a public prosecutor, that is, I agree. That we don't know who's but the office of prosecutor will be there. Our prosecutor can help you in that.
Yes.
So 7 days, let him try.
Yes.
Let him try. Electronically you can send, electronic. Get their email and send it electronically.
But there is no
Submit your email sending and before the court, then we can dispose it off. Once this condition is complied, that you issue his notice, then which whatever you need, 15 days, whatever, that can be considered.
Yes.
So list the matter on 25.
20, yes, 20. 25 is my lord, holiday. On 27 time. 25, 26, Saturday and Sunday.
Let it be within 10 days.
Yes, 24 10 then.
24. 2014. You can keep it.
Yes.
I'll take out another photo.
That is the lordship.
I just flipped through this.
Yes, lordship. It's
You
a
are
very,
mainly agreed by the delay.
exactly, lordship. It's a very limited prayer, lordship. I am not adverse to this DNA testing, lordship.
But the
But
thing is
fresh
that-
DNA testing may be conducted, lordship. This is my
Not at
limited
council,
prayer.
actually, of course, I would definitely ask the public prosecutor. This had come up before. Are you, could you go through this matter?
No, my lord. Otherwise, my lord, this is WPC criminal, so I will have to inform government advocate, my lord. General practice is that in case of WPC criminal, my lord, government advocate.
You could have filed a criminal petition also. Anyway, see, the thing is that from a recognized government laboratory, delay of 7 months, does not automatically mean that it will be, it may be tampered, whatever. And that aspect, prima facie, can be, you can grill the forensic person in cross-examination regarding that. That aspect is there.
Yes, yes.
But at this stage, since you have filed a petition with seeking some relief, so because otherwise, simply on the ground of delay, it will not be.
Lordship,
does not
this
have
other
sufficient,
respondent,
depth.
other,
Mainly, it will be very.
no, they have
superficial.
not explained the reason for this particular delay, lordship.
Yeah, the
And-
witness will have to explain.
Exactly, lordship. That is the reason why I have
It's
arranged.
there, but this.
Also, the difficulty is that under section 6 of the POXO Act, lordship, this, I have to appear before the court and I will be put behind the bar.
Lordship. Earlier, while the matter was rejected, Lordship, then the period of detention was, Lordship, 44 days, Lordship. Now it is 71 days. Secondly, Lordship, on the 13.
Right.
Earlier, Lordship, while your Lordship perused the CD, Lordship, in CD, it reflects that, Lordship, there was one technical analysis, Lordship, which shows, Lordship, presence of the accused, Lordship, on the place of occurrence, Lordship. But my specific stand is that, Lordship, I was not on the place of occurrence, Lordship, on that particular day, Lordship. Thirdly, Lordship, the learned court below has already granted bail to the co-accused Lordship and to the name accused Lordship, even the anticipatory bail Lordship. And only on suspect Lordship, the accused is not a name accused Lordship.
Third, learned counsel. This fairly submitted that earlier bail petition was rejected by this court on 17/9/2025 in BA 2973 of 2024. The learned counsel submits that the accused has completed more than 70 days in detention after his arrest on 3/8/2025. It is also contended that he was not at all present at the place of occurrence. So you get a updated sheet
Yes,
quickly. All for the case diary of Chanmari, PS case 195 of 25 to ascertain the latest stage of investigation. List on
2410.
14.
20. 2410.
Okay, are they ready for it?
The petitioner, he is in custody since 18/7/2025, my lord. If your lordship kindly sees the FIR, my lord.
18/7.
Yes, my lord. Lordship kindly sees the FIR, my lord. And if your lordship kindly comes to page number 18, the grounds of arrest, my lord.
Page 18.
Yes.
Should I see the FIR? first?
FIR is, my lord, at page. At page 16, my lord. May I read the FIR, my lord?
No.
Yes, my lord.
You want to read?
My lord, if your lordship permit, my lord.
No, go ahead.
With reference to the subject cited above, I have the honor to state that a report regarding missing of two persons, namely Jintu Moni Nath, 18 years, son of so-and-so, PS Mongoldoy, Dorong, Assam, and Bhaskar Jyoti Nath, son of so-and-so, was received at Mongoldoy PS by the MMR number so-and-so. Sincere efforts were underway to trace both the missing persons. In the recent reported attack on a camp of the United Liberation Front of Assam Independent in Myanmar, on 13/7/2025, Bhaskar Jyoti Nath, who had joined Alpha, had been reported to be killed, whereas Jintu Moni Nath had been found to be reportedly an active member of so-and-so. Based on the credible inputs and reliable sources, it has been revealed that the below listed accused persons have been actively involved in the recruitment of the above referred cadres into Alpha with the intent to perpetrate various subversive and terrorist activities across Assam. Besides, the accused persons have also been instigating the youth of Assam, including the areas under Dorong district so-and-so, to join the band outfit by spreading anti-national and anti-India sentiments among the youth and luring them into their ranks for armed and ideological warfare against the Indian state. The activities of Alpha One have not only disrupted law and order, but also posed a severe threat to the sovereignty and territorial integrity of the state. Hence, the below accused persons have committed the offences waging war, so-and-so, 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 my lord. Now, my lord, these list of accused persons which has been given, my name does not find place anywhere, my lord. The allegation against me that your lordships, my lord, finds at page 18.
Forwarding.
Your forwarding report, my lord. That is the allegation against me by the IO, my lord. On 18/7/25, informant, namely Inspector Chandanjyoti Bora, OC Mongoldoy Police Station, lodged an FIR at Mongoldoy PS to the effect that he have received a report regarding missing of two persons, namely Jintu Moni Nath, so-and-so, and Bhaskar Jyoti Nath, so-and-so, by the MMR number so-and-so, in the recent reported attack on so-and-so. Thereafter, this is the reflection of the FIR, my lord. Based on the credible input, so-and-so, so-and-so, it revealed that the FIR named accused person has been involved, so-and-so. Therefore, my lord, the grounds of arrest is just, my lord, during this investigation, the CDR of mobile numbers belonging to Bhavananda Das has been thoroughly analyzed and found his frequent contact with other suspected linkmen, active members of Alpha. One of the arrested active linkmen, namely Dharmendra Koilta, who is already arrested in so-and-so, so-and-so, has frequent communications, my lord. This is the allegation against me, and then they say, my lord, Objectionable item, that is camouflage hats and bags, were seized from the possession of the arrested accused person, which is supposed to be used in illegal activity. Now, my lord, camouflage hats and badges now these are available across the market anywhere, my lord. Even I wear one of those, my lord, dresses. So, my lord, just on the basis of that, my lord, to link me, my lord, that is perhaps not correct, my lord. And my
He was arrested on this thing because I was just, no, it's okay. I appreciate that. Submission.
And my lord,
But,
a
there are
co-accused-
This condition, sections which have been given, so we
Right.
have to see 43D that.
It doesn't apply because there is a judgment of this court, my lord, in the same case, my lord, where one of the co-accused has been released, my lord. There it has been held that the rigors of section 43D of the ULAP Act, it does not apply, my lord.
It will have to be, give me.
My lord. Yes.
Because section 18, 1310 is not.
Yes, my lord.
It does not fall.
My lord.
18, 18B and 20 falls in chapter 4.
My lord. Because your lordship should ever, my lord, in the case of Tufan Singh, even, my lord, if the statement of the co-accused is there, that is not sufficient to deny bail, my lord. And that has been highlighted in this order itself, my lord. And my lord, even the police, my lord, remand which was, my lord, sought for was declined by the honorable court below, my lord. Therefore, considering, my lord, the length of detention, lordships may be pleased to, my lord, release him with whatever, my lord, sureties, and I'll oblige with them, my lord. And I have already stated that.
Actually, we'll have to see the case
Yes,
diary.
yes.
Yes, and this
Yes, my lord.
43D satisfaction.
Yes.
is
yes,
Individual
lord.
specific.
Yes, ma'am.
So you would agree?
Let it be on 17th of October, my lord.
If it comes, no.
Yes, my lord, yes.
17 on দিগদাৰ হ'ব
Or month.
on 22/10 22 or 23.
Actually, this is actually in principle, very correct.
My
This
lord.
Tufan Singh,
My lord, yes,
conviction
yes.
cannot be best, but the,
And even,
but
my
the
lord,
main bail, just
my lord.
permit me for a moment.
No, I have
Uh,
stated one thing, if your lordship goes to record, my lord, if your lordship sees, my lord, page. Yes, I have not suppressed, my lord. At page 20, this man was a surrendered cadre, my lord. He has surrendered. This is a certificate given by the government of Assam, my lord. So, my lord, in that view of the matter, there might be some, my lord, talks, but that does not mean, my lord, that I am, my lord, involved in these activities.
No,
which
no,
has
it
been
is
alleged. Yes.
coming to the mainstream, that is welcome.
Yes, my lord.
That is welcome, definitely
Yes, my
welcome.
lord.
Now, what I was saying is that the governing law,
My lord,
main case
rigors
law,
of section
main
43D,
case
my
law
lord.
on 43D
D, yes,
with
my lord.
regard to UAPA
Yes, my
is
lord.
the still that the
Yes.
judgment of Jahur Ahmed.
Yes,
you know.
yes, yes, my
And in Jahur Ahmed, as you know, one of the things, even statements which may not be admissible in trial can be used
my lord.
for that. That has been
But
said.
then, my lord,
Academically, they can be critics of the same.
Man, what
But,
I submit.
since it's a judgment of the.
Yes, my lord,
Superior
definitely,
Court.
yes, my lord.
So,
But there are judgments
Tufan Singh
also, my lord.
is correct.
There are judgments also in
Very
respect to NDPS cases, my lord, that CDR records all will not be sufficient, my lord, to keep anybody. And that is why I say, my lord, yes, my lord.
Because a person may be in touch
Maybe,
with
my
the
lord,
acquaintance also.
maybe, that's
As a
what I
friend
say,
also.
my lord. But the case, whether I am.
Raises suspicion.
Yes,
it will
yes,
be
yes,
sufficient.
yes, my lord. And the fact that, my lord, after rejection of his remand, my lord, prayer made by the IO, by the, my lord, court below, there was no subsequent, my lord, any prayer made for further remand, my lord.
Okay.
Yes.
That's,
So if, my lord, the remand is not required, that means, my lord, the investigation, so long as that involvement of this man is concerned, my lord, so that is also not there, my lord.
Call for the case diary of Mongoldoy PS case number 146 of 25 and the section. The present accused petitioner Bhavananda Das is stated to be in pre-trial detention after his arrest on 18/7/2025.
My lord.
G. Chaudhary. Let this, can I keep this order?
Yes, yes, my lord. Yes, my lord.
List on.
23 23 or 22.
My lord. I am deeply aware. May I please, your lordship?
My lordship, FIR is on page 9. It is a complaint case, CR case, my lordship.
FIR at page 9.
Page 9.
Postcode.
Was lodged as a complaint,
2410.
but we can give a short date.
2410,
23.
2410.
Huh?
Yes,
23.
2310.
23.
Yes, highly available.
May it please your lordship. Lordship, this is 482 application, my lord. FIR page 15. May I read, my lord? With reference to subject to the above, I have the honor to inform you that today on, that is so and so, during disconnection drive at so and so village under so and so, some miscreants, namely Ismail Hussain, Babul Hussain, and lordship
Silent cause.
and others, my lord, have misbehaved with our staff, verbally assaulted and tried to physically assault and stolen some seized materials, my lord. My lord, what happened is the petitioner is the valid, my lord, a consumer of electricity, my lord. On that particular day, my lord, they started disconnection drive and entered into our house, my lord, and forcefully tried to disconnect. My lord, we have, even before, there was no outstanding bill, page, my lord, 21, page 21, my lord. This is
No
the-
problem. Let us call for case diary with interim
Yes.
protection.
Yes.
My lord.
Heard 482 bail application. South Salmara PS case number 102 of 25 under section so and so. The allegation in the FIR dated 19/8/25 lodged by one Narayan Das is that during disconnection drive at the stated place on behalf of the electricity authority, some persons named in the FIR misbehaved with the staff
Such a this.
and tried to physically assault them and also stole some materials. Call for the case diary from the concerned police station. That will likhil lein. In the interim, in the event of arrest in connection with this case, they may be allowed to go on bail of 20,000 each. How many petitioners are?
Oh, 4 petitioners, my
Four
lord.
petitioners, 20,000 each with the surety of the light amount to the satisfaction of arresting authority. And subject to the condition that they shall cooperate with the investigation. Full stop. List on.
311.
My lord, they will appear within 10 days.
So, cooperate and also appear before the IO, making themselves available for examination. 311.
IMDb.
311. One, again one.
In this case, my lord, as per my instructions, search sheet submitted, my lord, in this case. Today is 90 days. Search sheet submitted on 22/8/25.
So in that case, you just need to say serve notice.
Lordship. In the meantime, else I may be called for lordship.
Now you serve the notice,
Lordship.
then you can see. Call for the scanned case diary and scanned charge sheet of Likhapani PS case number 41 of 25. That's so and so. The accused is stated to have been arrested on 14/7/2025. It is submitted by the learned prosecution that charge sheet was filed on 22/8/25.
Yes, 22/8/25.
CS number.
By CS number 46/25.
The steps may also be taken for notice upon the informant to the concerned police station.
Yes,
List on,
on 29/10, my lord.
is it okay?
Lordship.
29.
29.
29. Approved, huh? Yes.
May it please, Lordship. It is an anticipatory bail prayer
in an NDPS matter of intermediate quantity. On 7/8, house of the accused was raided. He was not present and his wife was arrested on the allegation of recovery of 93 grams of heroin, suspected heroin, lordship. The wife was arrested. At that time, she was at advanced stage. Accordingly, at page 15, lordship, her bail application was mentioned and accordingly she was granted bail on the ground of her health conditions.
Pregnancy.
May I request lordship at page 19, the wife of the accused was of advanced stage and her expected date of delivery is 1/11, lordship. So while pending for calling CD, lordship, I am requesting for an interim bail protection, lordship, so that she can remain present with his wife during this period. 1/11, hardly 15 days left, lordship.
She was also arrested. She was granted bail.
She was granted bail, lordship. I have annexed the order, earlier order, lordship, at page 15, 16 and 17, lordship. At para 5, specific mention was made, lordship. Petitioner is carrying a pregnancy of 8 months. She was arrested. She was in behind the bar for 43 days. So only on that count, lordship, on humanitarian aspect, I am praying for an interim protection to the accused husband, lordship.
Anything?
Because her expected date is 1/11, date of delivery is 1/11 and nobody else in his house, lordship, to look after the pregnant wife, lordship.
Anyways. 482 bail BNSS application. Lahori Ghat TS case number 171 of 2025. So the allegation in the FIR is about recovery of an intermediate quantity of suspected heroin from the house premises of the present accused living with his wife. Full stop.
93 grams, 93.55 grams.
Within bracket 93.8 grams, 93 grams, no? 93 grams. Excuse for that. It is submitted by the learned counsel that the wife of the present accused, who's in an advanced stage of pregnancy, was arrested. However, she was granted regular bail. She was granted and regular bail on 18/9/2025. Drawing attention to a document, it is submitted that her date of delivery is fixed on 1/11. 2025. And that there's none to look after her at this stage. And therefore seeks some interim protection. Full stop. Third, additional people. Totally call for the case diary. Considering the aforesaid health aspect of the wife, wife of the present accused, it is directed that in the interim, in the event of arrest, 30,000 with one security. The satisfaction of arresting authority. Subject to the condition that he shall cooperate with investigation, he shall appear.
Definitely, lordship.
Making himself available for examination. He shall not hamper or tamper with evidence and not indulge in any illegal activities. You fix a longish date because first, about a week after.
Yes.
At least a week after this thing.
18/11.
Maybe 18/11, lords. Obliged, lords.
Yes. 24.
May I please, your lord? May I please, your lordship? Lordship, I am the petitioner.
Inform.
Your lordship, actually, Mr. KL is on legs. Kindly pass over the matter for the time being.
Just a minute. Okay, don't worry. This case diary has come.
Yes, this is the scan copy, your lordship.
Here for the prosecution. So let us wait for him. He's standing counsel. Wait for, you want to make your submissions?
Yes, lordship, if possible, may allow to submit my my submission, your lordship.
Should I do?
Okay, your
Lordship, it would be much better if Mr. KL is here.
Okay. kindly accommodate. For some time.
Deeply obliged, obliged.
My lord, item number 25, 31, and 32, same PS case, my lord, in case there is
20.
25, 31, and 32. In all these cases, search sheets already submitted, my lord. In this.
25, 31 and 32.
Records was a question copies of record.
Maybe call.
It is commercial quantity,
Yes,
so we'll
sir.
need it. It is submitted by the learned prosecution that in the meantime, charge sheet has been submitted pursuant to completion of investigation. Call for the scanned TCR of North Guwahati PS case number 36, no, scanned case diary and scanned charge sheet of North Guwahati PS case number 36 of 25. That will be more useful.
Yeah,
CD and charge. The order sheets we don't need actually. 21C, and 36 up to 25. The accused is stated to be in custody since, in detention since 11/4/2000.
11/4.
2025. Two persons, two accused persons. List the matter on.
Altogether 4 persons.
4 persons. 4 persons. Here, 2 or do the
Other, yes.
25, 31 and 32.
Obliged.
No, date.
Date, my lord, on 4/11, well, 4/11.
Because here in this case,
6 is already
more than 6 months.
Little shorter date.
This is from Kamrup only, Lordship.
On 31/10, well,
31 or 29? One of
yes,
this.
31.
30.
31/10.
I don't think it's I don't, right. Okay. Obliged.
31 take.
Twenty-six.
Session is.
We have received a scan copy, Lordship, PCR received, and DPS commercial quantity.
Commercial quantity. So let him come.
Only the search sheet submitted, search frame, not frame yet, Lordship. And
No,
and-
we
and
have-
search sheet is not completed, also the entire TCRs. Full search sheet is not there. How many witnesses are, PWs are there?
Charge sheet, we need the charge sheet and case diary.
Yes.
And
See,
copies of the
search
charge
sheet
sheet and
submitted
case
on
diary,
dated
and in any case 37 has to be seen.
Yes. Search sheet submitted on 21/8/25. Under section 22C, 25 and 29 DPS.
Anyway, let him come, maybe he may be busy in another court. Thirty.
29 also.
Respondent has appeared. You are appearing?
33.
Lordship, kindly pass over for timing, Lordship. My senior is on legs, Lordship.
You are appearing as amicus or
No, my lord.
engaged?
Yes, my lord.
After some time?
Lordship, after some time. Deeply.
Yes, it is the.
Case diary, yes, received.
Has been
And Lordship.
May I please your Lordship? My lord, the petitioner was surrendered, my lord, on 17/12/2024 before the learned special judge North Salmar of Hypering. My lord, the FIR is page 10. A FIR was registered, my lord, against the present petitioner along with 3 other total 4 persons, my lord. Under section, my lord, here 366A, 379-34, and it with section 4 of POXO. And subsequently, my lord, after complete the
TCR.
Service
Service,
service
no, no,
also-
office note I checked. It is also awaited, last office note. So you, can you
Okay.
take instruction?
I'm praying for shorter lordship because lordships tribes if newly declared cancer patient.
The prosecution said take instructions regarding service upon informant. Mr. Chutia, learned counsel, seeks a shorter date submitting that the wife of the accused is suffering from cancer. So, I think Friday? Friday,
Friday lordships, Friday
17:10.
lordships. I'm obliged lordships.
Where it will come from?
Sonitpur lordships,
Nidpur.
Sonitpur lordships.
Did we fix it on Monday?
Lordship, Monday,
Take a chance.
lordships,
Okay, Friday, 17.
lordship. I'm obliged lordship, 17.
This is your lordship. In this, I have filed objection, lordship, written objection on 25th 9 now. It's not there in the record.
Oh,
Let that come up along with.
POCSO matter?
Yes, lordship. I filed my objection on 25/9. Along with that, this matter may be listed, lordship.
The learned counsel appearing for respond number 2, informant, submits that the written objection file has not yet come into the record. The same may be brought into the records. It is, in the meantime, this has come.
Case diary, we have received a case diary.
Case diary has been received. And be retained with the case record. When should we, it can be brought on record immediately. On Thursday, we can.
Yes.
Or Friday, lordship, whatever is convenient for lordship.
24th.
Friday, one.
Yeah.
17th.
May please, your lordship. My lord, here.
This
the-
case trial is not started, no?
Yes, my lord. He is in jail since, my lord, 301 days. And he willingly surrendered before the court, my lord. And the surrender order, my lord, I have annexed, is, my lord, 22, my lord. But at 4 person initially naming the affair, now, my lord, discharged 2 accused person and 2 is, my lord, 1 is filed. And the present petitioners against the proceeding is going on. He is in jail, my lord. And every date, my lord, he is producing before the court, but witness is not coming, my lord. So page 22, my lord, I have willingly surrendered, my lord. The court may presume that he is law abiding person, my lord. And since a person will willingly come and surrender before the court, and we can think that, my lord, he will face the trial, and subsequent date also he may appear, my lord.
You have received the record.
TCR received, we have to.
Received,
go through
but
it.
notice, I will.
Notice,
searching.
he is appearing for a respondent.
Okay, you are paying for respondent number 2. Then we can hear. We can hear. You can-
Only thing is that also we have to go to the records, so allow us some time to go through it.
No, the case is nothing because no witness is examined.
No, no,
I have
diary,
annexed.
diary part, diary part. Diary you have received?
No, TCR received.
No, it will have the charge sheet, right?
Yes.
So see the
Yes.
materials in the charge sheet. Take some time. After some time.
Documented radio.
Oh.
Lordship, conducting counsel is on another court, so that may be taken up at 2 PM.
The record receipt.
Record, TCR received. We have to go through and.
What is the matter? Take it up later on, no problem, but that's.
302 IPC lordship, and arms act also there.
Extremely voluminous, actually.
So we have to go through it also. lordship.
No, no, that's why I'm asking, what kind of matter? 302.
302.
Then many accused it seems.
25-1 capital A also the arms act.
May I please before your lordship, Mr. S.C. Vishwas is appearing in this matter, lordship. He is engaged in another court. I am praying for a passport for the time being.
For it application, Lordship, city has been called for.
Diary received.
They received, Lordship.
Lordship, in this case, Lordship, some of the accused has been granted bail, Lordship, by your Lordship.
Lordship has gone to the case, there is a Pan Bazar case, some vendors of food hut, Lordship, suspected to be thief, brutally assault.
Investigation must have, what is the progress on investigation?
Progress, Lordship.
Slightly forgotten, anyway, so.
I have the Lordship, I have the orders, Lordship may see, Lordship.
Pardon?
I have the orders, Lordship may see.
There are two persons, no? Dhrupajyoti Pathakam.
Yes.
They are named in the FIR?
Yes, Lordship, all the accused are named only, Lordship. FIR in page number 13, Lordship. Lordship, but they were not present when the incident occurred, Lordship. The incident occurred in the morning, Lordship, but they used to open their shop, Lordship, during Lordship at 10 AM, Lordship, from 10 AM, Lordship, during the college hours, Lordship.
Only the investigation, Lordship, blood sample was sent to FSL, Kahili Pura, Lordship, that is awaited, Lordship. As per the PM, death was due to coma as a result of the head injury sustained during life.
I mean, the facts, yeah, the law very well. Expert to allegation to law very. The present two accused persons seeking bail were arrested on 9/8/2025. Judicial custody at present. Full stop. The learned counsel places before the court orders of this court granting bail to three co-accused were also named in the FIR. The case diary has been received. Should I see it or you can submit?
Lordship, only thing is that some people said, several persons were
Yes.
there,
Now I'm
brutally assaulted, and one person, one is dead, Lordship, Tilok Medhi.
Yes,
And there are
unfortunately,
name,
yes.
witnesses named only Hirokjuti Medhi, Amarjuti and Sariful, they are named. These persons were named or not in the, by the witnesses. There are several persons were there. It is very difficult to identify by
that
name.
is So, investigation, this is.
Only the
pending
wait for the FSL report.
FSL report. As per the prosecution, the investigation has progressed sufficiently, but not completed. And it appears that forensic report is awaited. Considering the length of detention, progress of investigation, and aspect of parity, the present two accused persons are allowed to go on bail of rupees 30,000 each, with a surety of the like amount each to the satisfaction of the concerned learned court, CJM,
Yes,
Kamrup Metro. And subject to the conditions that they shall not hamper or tamper with evidence. They shall not commit any illegal activities or offense. Return the case diary, bail petition stands allowed and disposed of. I'm keeping this, huh?
Yes, yes. Bless, Lordship.
We have not received the case. A report from the communication was made before from the IO Lordship. The case investigation into the case has nearly been completed and search sheet is prepared for vesting. Therefore, praying for fix another date.
Today is 90 days in custody.
90 days.
What is the section?
14021.
310 plus 2 loss. 140 plus 2, 317 plus 3.
Earlier bill was rejected
Rejected.
by this court, by this
Yes,
court.
Lord.
So Lordship, wait for some time, Lordship, we'll take instruction whether Sassid is submitted in this case or not.
Hmm.
Because,
No, he has stated already.
Yes.
Just a minute. Oh, the allegations are a bit grave. Hmm. But anyway, so if there's about a month has elapsed since the asked rejection. What is the investigation is completed?
yes, we have not received a case, by intimation is there, the case investigation into the case has nearly been completed. And Sassid is prepared for vesting.
Betting.
So
His wife is pregnant.
Yes,
Wife is pregnant.
Yes.
That aspect can be seen also. We can allow also. Or you want a copy of the? I think, because this aspect also has to be seen.
already written, my objection will be accorded in this regard. Lordship.
Yeah. And Ahmed Learned Council and so on. Goswami. It is submitted that the earlier bail application was rejected by this court on 15/9/2025. Noticing the incriminating materials against the present accused. It is submitted by the prosecution, objecting to the bail. It is submitted by the prosecution that intimation has been received that investigation is almost completed and charge sheet has been prepared for vetting. TTTING, vetting. The wife of the present accused is stated to be also pregnant for about 26 weeks. 26 weeks. Keeping the aforesaid, in the aforesaid facts and circumstances, I am of the considered view that the accused can be allowed to go on bail at this stage, subject to conditions. Thus, he is allowed to go on bail of rupees 40,000 with one surety of the like amount to the satisfaction of concerned learned court. Boroma, right?
Boroma.
Nobody?
Baksal also.
Oh, Vaksana. Satisfaction of the concerned learned court within bracket CJM Vax. Subject to the following conditions. Number 1, he shall not abscond. Number 2, he shall not hamper or tamper with evidence. Number 3, he shall not indulge in any illegal activities. A violation of bail conditions will entail cancellation of the bail. Petition stands allowed and disposed of.
Deeply obliged.
Application, my lord, it's a offense, my lord, LSDM, my lord, 77, 79, 351, 2, and 67A of IT Act, my lord. The BNS sections which charged here, my lord, these are all bailable, my lord, except section 67A of IT Act, my lord, which is 5 years of punishment, my lord. First offense, my lord, subsequent offense, 7 years, my lord. My lord, and the person is in custody, my lord, not as on today, my lord, 53 days, my lord, 60 days offense, my lord, and the allegation, my lord, page 9, my lord, the affair, my lord. There is a love affair between the informant's daughter and the present petitioner, my lord. And from 2022, my lord, it is in the affair itself mentioned, my lord, by the mother, my lord.
Can I read it?
Yes, my lord, yes, page 9, my lord.
That's a, I have even some photograph, my lord, with to her sister, my lord. My lord, I spend everything, my lord, to fulfill her luxurious demand, my lord. Now, my lord, what happened, my lord? She admitted in my lord Pokrajar in BSc nursing course, my lord. Thereafter, my lord, she having affair with another boy in that college, my lord. When I came to know, my lord, then this court, my lord, started, my lord, 53 days, my lord.
Allegations are, FIR allegations are very serious.
Yes, we have not received a case diary also.
Case diary will be necessary.
My lord, 60 days offense, my lord. Already 53 days, my lord. 7 days left, my lord. And my lord, the mobile phones, my lord, the LS, that is already been seized, my lord, as per the forwarding report also, my
So
lord.
let us call for the issue reminder for the case diary and fix it on the 61st day. If it's not there, he'll get it.
My lord, everything has been seized, my lord.
No, because without seeing the CD.
And in the affair itself, mother says, my lord, we have love affair.
Because,
But regarding the, my lord, the obscene photograph, my lord, that is, my lord, not, there is some exaggeration, my lord. I give the photograph which we have taken, my lord, both are there, my lord. And I sent to her mobile phone, not.
1st September.
The ground authority, it may, I mean, it's
Just a
up to
minute.
me.
Patasar Kusi, can you
Yes.
take instructions?
Yes, his intimation was made from SS Lordship.
Can you take the instruction? Because you tell him that court was asking several dates have passed.
Lordship.
Several dates have passed. Let him take the instruction, Mr. Sarma.
Lordship.
And today only he'll take the instruction. We'll take it up in the second,
Second up.
in the second up, in a little after 2. He'll take the instruction.
Lordship.
So what is the status? Why case diary has not come?
Lordship.
Much obliged.
Long time.
My lord, in this case, my lord, the interim was granted and the CD was called for. The present petitioners with your lordship is not named in the FIR and no way involved with the incident, my lord. My lord, the incident was taken place, my lord, with the second owner of the vehicle, my lord. His vehicle is already interims.
Diary has come.
Yes, my lord, case they received.
We'll have to now do the exercise of, 37.
Yes.
Because, at that stage, since he was not named. Let me order to find first paragraph 1, 2, 3. 4. The despite the nature of the penal provision, I will do the hearing. I'm just nature of the penal provision given at this stage. The accused was granted interim bail by order dated 22/9/2025 for the reasons stated in para 789 of the said order. The case diary has been received in the meantime.
Yes, case they received, my lord. Otherwise, commercial quantity, my lord, 10.712 gram of morphine recovered. 2 persons were arrested, driver and helper of the vehicle. Now, ground of the petitioners that he is the driver of the, my lord, vehicle truck, which was, my lord, here one agreement I have found in the case diary that is dated, my lord, notarized agreement, my lord, regarding but genuineness of that agreement, my lord, 17th day of April 2025. Here, my lord, contradiction is your lordship may kindly peruse statement of Ali Ahmed. He has stated that, my lord, I along with one Azad Khan has purchased the vehicle from one Joinul Islam at an amount of rupees 10,50,000. That is the statement of the one of the accused, my lord, Ali Ahmed. He is the
accused.
Accused, my lord, driver of the vehicle, my lord, Ali Ahmed. And now here, my lord, I have gone through the agreement. I have found that The present petitioner, there is a notarized agreement, my lord, that is although my lord, value is 10,50,000 with one Sharifuddin. Your lordship may kindly peruse, my lord. Just because he is in interim, so he appeared, his statement recorded.
My lord,
But the statement of Ali Ahmed and the present petitioner is, my lord, and regarding the genuineness of the debt notarized agreement,
So we
there is
don't know.
nothing in the CD, my lord.
It was recovered from the truck.
Truck, my lord. Secret chamber of the truck, secret chamber in the
Chamber
truck.
of the
is there.
truck.
Yes.
And the present petitioner is stated to be,
He is, my lord, stated that his case is that he is the owner of the
he's the
vehicle,
owner of the truck.
owner of the truck, my lord.
he was the owner of the truck, but the truck has been sold out to one Sharifuddin. So the entire allegation is there, my lord, but the petitioner is no way involved, my lord.
Your
Petitioner is not aware what is going on, my lord, because the truck is already sold out, my lord. An agreement is, my lord, as my learned friend has stated, the
regarding-
agreement is there, my lord.
My lord, some other aspect yet to be, my lord, investigated, my lord, regarding the transfer of the name of the present petitioner and regarding that notarized agreement, value is 10 lakh, my lord, 500. Your lordship may kindly peruse the statement of Ali Ahmed also of the
My lord,
accused.
that Ali Ahmed, another co-accused, my lord, has already been arrested. They are the only accused person, my lord.
He stated
I
that
have annexed the,
he along with one Azad Khan has purchased the vehicle name of, my lord, someone other, so both contradictory, my lord.
I have also annexed the forwarding report. The involved persons are already arrested. So the petitioner is no way involved because he vehicle is not belong to him. It is already sold out.
And regarding, my lord, that aspect
The
investigation.
petitioner is no way responsible, my lord, also, my lord. He is not aware about the allegation. The allegation is there, but what is the responsibility, my lord?
According to this statement, this purchase from
He along with one Azad Khan, my lord.
Azad Khan.
Azad Khan.
But the notary agreement is with Sharifuddin.
Sariful.
Otherwise, what are the other materials? Because
Other
look
material,
at it,
because, my lord,
look at it from the, initially you look at it from the point of view of 37.
yes, 37. Otherwise,
Whether
no,
it can be said that prima facie he is not guilty.
no, it
Can be
cannot,
said?
right,
Then if that test is passed, as you know, then it becomes a normal bail application.
yes, yes.
Then
Otherwise,
the
my
things
lord,
can be
regarding that
First,
aspect,
that is, test has
Yes.
to be passed.
as because, my lord, petitioner has already obtained interim protection, so whether the genuineness of that notarized agreement, value of which is, my lord, more than 10 lakhs, my lord, whether genuineness of that, because that, my lord, notarized agreement is otherwise contradictory with the statement of, my lord, accused Ali Ahmed. So some other aspect regarding the transfer of the, he stated that that vehicle agreement was of in the month of April. So thereafter, my lord, whether the registration of the vehicle, whether the other, my lord, owner statement has to be, my lord, recorded, that, my lord, that some of the investigation needs to be paid to find
He-
out.
He says that he could not pay the EMI, so he transferred the vehicle.
Otherwise, he cannot transfer only because transfer, my lord, the vehicle, while the vehicle at this stage, because only
The executive asked him to run it,
yet run it, my lord.
detain and deny, recover drugs from the vehicle.
Otherwise, that owner's statement need to be, my lord, recorded by police, my lord. Sorry.
I see. He has filed a complaint case also, he says.
My lord, I filed a complaint case, my lord.
And those records.
My lord, I appeared with the lordship's order, my lord, before the investigating authority, my lord.
Seeing your statement.
My lord, I will, as and when required, I will appear, my lord.
Just a minute. Give me. Okay.
Let him, my lord, produce that record of the complaint petition, what he has filed before the trial court, my lord.
Just.
Yes.
The driver and the helper are the brothers,
Yes.
the brothers.
The cousin one.
It's true. So, would you propose that investigation can continue? for some
Yes,
more time?
but some further investigation need to be
extend this
required
thing.
regarding the transfer of the vehicle in the name of the.
So, those documents can be collected?
Yes, otherwise he also submitted that he has also lodged one CR case. Let him produce the record of that
Can-
CR
that
case.
can be done.
When
Case
he has filed that CR case, my lord.
Case diary
What are
is
the-
produced. The case diary, peruse the relevant portions of the case diary, including statement of the driver and helper of the vehicle in which suspected contraband / drugs were found. Full stop. The present petitioner claims to have sold the vehicle to one Sarifuddin due to being unable to pay EMI. It is full stop. The learned public prosecutor submits that no, it will not. However, from the statement of one Ali Ahmed, co-accused Ali Ahmed, it appears that the vehicle was purchased by them from the present petitioner. One aspect is that, this is a matter of investigation, so you cannot jump to conclusion, but if there is a well-built secret chamber,
Yes.
properly built secret chamber in a
Chamber.
vehicle,
Yes.
then there might be some needle of suspicion towards the owner also. Because driver alone may not generally,
No,
but
generally.
only that is not sufficient.
sufficient.
Criminal law does not proceed like
yes,
that,
yes.
should not proceed like that.
Yes.
But some needle of suspicion might go. If it is
Might
just located below the seat or something,
yes.
but properly, chamber is made anyway, it would be fair at this stage, let the investigation continue for some more time, with extension of interim. In the given circumstances, the case diary may be returned back and procured again after further progress in investigation. Full stop. The interim bail granted to the accused by order dated 22/9/2025 stands extended till the next date of listing. I have not found anything
Yes,
to
yes,
justify
yes.
cancellation of this.
Yes,
Prima
ma'am.
facie.
Otherwise, my lord, if only to that extent regarding that, my lord, notarized agreement, I will
And you can submit your
CR case record. ma'am.
List
On 18/11, my lord. It will take some time. 18.
list the matter on 18/11/2025. Return the case diary.
Look, create as bail application, my lord. Lordship was pleased to call for the case diary, my lord. Here, my lord, I have filed one additional affidavit, my lord.
Okay.
Lordship may kindly take up the additional affidavit, my lord. Page 23, my lord.
Bank matter, no?
My lord. Here, what happened, my lord?
Just, what is the page number?
Page 23, my lord.
22.
Because the case pertains to the year 2016, my lord. And as soon as I came to know that some malpractice has been committed in my account, I lodged an FIR on 4/1/2016, asking for an investigation and to name the culprits. My lord, this was duly received by the concerned police officer of Dispur, but subsequently, my lord, I am not aware as to the status of the case. On one or two occasions, I inquired, my lord. They said that they will call me, but ultimately, my lord, this remained, my lord, at the stage of filing of the FIR, possibly, my lord.
This.
And my lord, lordship has granted bail to the co-accused person, my lord. That order-
Paras Gargia, he has filed this
FIR.
FIR
my-
against
Against the persons
who's
unknown
stated to be
person,
his neighbor.
my lord. Ranjib Hazarika, who happens to be the main accused, ex-bank employee, my lord. He converted, my lord, funds deposited by others in various accounts, my lord.
Ranjib Hazarika is in custody?
My lord, I am not aware, but his
Ranjib-
wife has been granted bail by your lordships, my lord. That order,
Ranjib Hazarika also, my lord, interim bail already granted by your lordship, my lord, in Ranjib Hazarika.
Oh.
Is it?
wife's order, lordship will find as page 27, my
This I found.
my lord.
Earlier, your
Interim bill.
interim bill. Ranjib, Jumi Das was granted absolution, that was BA, my lord.
And another accused, my lord, whose account was used by this Ranjib Hazarika, he has been granted the privilege of bail by your lordships, my lord. That order I am placing before your lordships, my lord. So I was also issued notice under 41A. I duly appeared, my lord. My statement has also been recorded, my lord.
Yeah, no, to place.
Yeah, no, no, speak for us.
No, it G2 bill to this.
Oy, Kumar, Gautam Kumar.
Gautam Kumar, yeah.
Gautam Kumar.
Yeah.
What is the investigation with regard to this person?
My lord, regarding the earlier, your lordship has perused the, my lord, case there because other matters. So regarding the present accused persons, my lord, your lordship, those accounts which were misappropriated by the bank employee, my lord, Ranjib Hazarika and his wife Jumi Das, my lord. Some of the, my lord, an amount of rupees more than 13 lakh transferred to the current account of the present petitioner. And my lord, thereafter, his against allegation of the present petitioner is that. So, my lord, he along with, my lord, invested, he conspired along with other accused persons
prima
for
facie.
misappropriating the entire amount. And regarding other persons, Jumi Das, my lord, BA, that Jumi Das was already granted bail.
And he has filed this additional affidavit and this FIR.
Yes, yes.
4/1.
Yes.
My
FIR is dated 4/1/2016.
What is not registered as well?
Register.
No, case, that case was not registered, my lord.
But they received it, my lord.
Regarding that, my lord, additional affidavit also copy of the with not with me, my lord. Otherwise, that case was not registered, my lord. I would like to point out, my lord, from his petition, my lord, one paragraph 7, my lord, regarding
Petition, his main petition.
his main petition, my lord.
Para 7.
Para 7 and 8.
Okay.
That the petitioner, may I read, my lord? That the petitioner begs to state that in the instant case, so far as allegation of transferring money to the account of Messrs. CDS Business Associate, that is the present petitioner's account, my lord. The petitioner had no knowledge about such transfer of money to his account, as there was no message alert facility against that account. And the said account being CC, there was no passbook against the same, and petitioner was unaware till he was called upon by the investigating agency that the money did not belong to the said Ranjib Hazarika but to the victim of the instant case, and as such the petitioner may be granted privilege of pre-arrest bail. So my lord, only when at the time of receipt of the notice, he came to know about that, my lord, that those amounts were, my lord, deposited in his account. Now, my lord, that affair, my lord, he has submitted before your lordship by way of that additional affidavit.
True, my lord. But
then,
that affair, my lord, that
And
I
they-
procured from the police station, my lord.
Thereafter, my lord, paragraph 8, that the petitioner begs to
Contradictory.
state that from the perusal of the FIR, it is apparent that money amounting to rupees 13 lakhs of Messrs BL developers was given to Ranji Bhazarika. So, my lord, amount of rupees 13 lakhs were transferred to his account. my lord.
No, my lord,
So
two
that is the
accounts,
allegation
two
against-
accounts, my lord, money was transferred. 6.5 and 6.5. Lordship 13 lakh in its entirety. Now lordship will kindly see the case pertains to the year, with all respect, my lord, 2016. I duly lodged an FIR asking for an investigation as to the culprit, my lord, and mentioning the name of Ranjiv Hazarika specifically, that without my knowledge, my lord, with all respect, he did this misdeed. My lord, I am a victim of circumstance, my lord. I on bona fide belief left some check due to my business liabilities, my lord, and which he converted to his own use and gain. So 2016, my lord, case is based on documentary evidence. Lordship will kindly protect me. I will into cooperate with the investigation, my lord. Possibly my custodial detention, possibly in my humble understanding of the matter, my lord, possibly not required because I am cooperating and I will cooperate, my lord.
And regarding one Babul Kumar, in whose accounts also, my lord, Messrs
Oh.
Bogala, your lordship has granted bail, that is a case because he was in fact the servant of the maid servant of the present two accused, my lord, Zumidas and Ranji Bazar. But the present petitioner is, otherwise there is no relation.
My lord, he is my friend and neighbor, my lord. Lordship, I have mentioned it in my FIR as well and as well in my petition.
The learned counsel submits that an additional affidavit has been filed from their side. uh, Bringing on record certain facts, certain contentions from their side. It is stated and submitted that co-accused Ranjiv Hazarika is the neighbor of the present petitioner. And in connection with some business transaction and in good faith, he had handed over some checkbooks which were misused to conduct these illegal transactions of money, some of which also came into the account of the petitioner. In this regard, the petitioner also submitted an FIR before the court. However, it appears that, and as pointed out by the learned prosecution, that no case was registered pursuant thereof. The learned prosecution has also brought out a contradiction between the said contention and the contentions in para 7A8 of the bail petition. What is the progress of investigation?
Investigation, my lord, yes, case is FIR laws on 2 years of 2016, but here regarding other investigation, substantially progressed. my lord.
Two co-accused have already been granted bail by this court. It is submitted by the learned public prosecutor that there is significant progress in the investigation. Despite the nature of the allegations and the nature of the alleged offenses, considering the progress of investigation and the fact that some co-accused standing on similar footing have been granted bail, this bail petition is also allowed. Accordingly, it is directed that in the event of arrest, 30,000 with one security.
Deeply obliged.
With the satisfaction, and he will appear.
Mine.
Cooperate with the remaining
Mine.
investigation.
Mine.
Appear before the IO, making himself available for examination.
Mine.
He shall not hamper or tamper with evidence.
Deeply obliged.
Entail cancellation of bail, violation.
I am obliged.
Because
Standing at 24.
Wait, please, your lordship.
Yes. You
Lordship,
can go ahead. Take
yeah,
note.
this is the charge matter, your lordship, and the accused person was arrested on 10th of March 2024. And in this case, your lordship,
Commercial quantity.
the forensic, yes, lordship, for commercial quantity, but I am in custody 1 year, more than 1 year and 6 months. And your lordship, in this case, what happened, your lordship? On the status report of the trial court on order dated 28/11/2024, the accused was arrested on 10/3/24, and the forensic has submitted on 28/11/2024. Means after 235 days, forensic has come, your lordship. And your lordship, the forensic has submitted after 180 days, means 180 days is the statutory period. After 180 days, the forensic report has come in the trial court. This is the proof, your lordship, 2/11/2024. এখন দি দিয়কচোন।
Investigation was not completed within the statutory period.
Investigation is completed, your lordship. Today, 1 year, 7 months in 3 days in custody, your lordship. And your lordship, I am going to the grounds, your lordship, of the long incarceration, your lordship. Now 1 year, 1 year, 7 months, 3 days in custody, and charge has been framed on 18/9/24.
Charges.
Still, yes, lordship. And the last order, your lordship, of the trial court, just on status. They are mentioned on 15/9/2025. On that day, witnesses come, but no witnesses has been cross-examined still, your lordship. And there have 8 witness. From the 8 witness, there have no any witness has been cross-examined. So your lordship may allow for submit the bail application number 3487/2023.
Okay.
3487/2023. In this case, your lordship, video. In this case, your lordship, on the para number 3. Counsel, relying on the decision of the Honorable Court in the case of Muhammad Muslim versus State and City of Delhi, reported in AIR 2023 SC 164, contended there is no scope for early disposal of trial, and the petitioner has been under incarceration for more than 1.5 years. And in my case, I am in custody 1 year, 7 months, 3 days today. And your lordship, paragraph number 7. Grant of bail, paragraph number 7, grant of bail on the ground of undue delay in the trial cannot be said to be fettered by Section 37 of the NDPS Act 1985, in as much as Section 436A of the CRPC is made applicable to the offences under the NDPS Act by the Honorable Apex Court in the case of Satendra Kumar Antil versus CBI, reported in 2022, 10 SCC 51. Paragraph number 7. Paragraph number 8, lordship. Section 36A of the NDPS Act 1985 mandates that the offences under the Act are triable by the special court in the considered opinion of this court. Such mandate of the legislature is to achieve the object that the trials are completed at the earliest possible time, inasmuch as the condition of bail and other provisions under the Act are very stringent in nature. It is also well settled that reasonable, fair, and just procedure in a criminal trial is a constitutional obligation on the part of the state. A speedy trial is also one of the dimensions of the fundamental rights to life under Article 21 of the Constitution of India, reference Raghubir Singh versus State of Bihar, 1986 for SCC 481. Paragraph number 10, your lordship.
I've seen.
Paragraph number 10, your lordship. And the accused
No,
person,
the embargo was, the court held in this case, in this order, that the 37 application, it is not, the test was passed in favor of the accused. It was in favor of the accused.
lordship, the accused person has granted bail on the 1.5 years in custody, your lordship, in this case. And your lordship, in another matter, on BA number 1364/2024, in
No,
this
para 16, you see, para 16, the court has held in this order that there is no ground to believe that the petitioner is guilty. That means the test was passed in his favor under 37. Sorry, you wanted to say.
yes, bail has been granted.
It's granted. But
Para 20.
yeah, that's true. No, there are two aspects to the matter. One is the 37. Whether 37 test is passed in
Yes.
favor of prosecution or in favor of the
Accused.
defense, right? The other aspect is that in all these cases, that at what point of time the Article 21,
21.
you know,
Yes.
prevails over the statutory
Yes.
restriction. What point of time?
Consequently, it has been held by Honorable Supreme Court as well as by our High Court. Lordship is to see the facts and circumstances of the case, how the trial proceeded, how many date has been fixed. That is to be seen by your
That is,
lordship.
everything has to be seen. Well, in Najib, of course, subsequent decisions have come after Najib, PA Najib,
Yes,
Union of India. So that is, I've forgotten the paragraph number. One paragraph has been devoted by the Honorable Supreme Court to lay down the law on this point at that time. Subsequent decisions have come, as I said, that when this will be triggered, that how to balance statutory restrictions and Article 21. One short paragraph is there anyway. So kindly now submit on the 37 in this case, materials.
Lordship here, if my learned friend completes, then I can.
Yes, you have completed, or should I, let me come to him and then I'll get back to you.
Yes.
Huh? That will be better. Because first that hurdle has to be seen
Lordship
from
here.
your point of view.
He was arrested on 10/3/2024
Yes.
along with 2015 gram of morphine from his conscious position.
201,
15
that is commercial quantity.
gram.
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 That is commercial.
Yes, commercial.
Commercial.
Psychotropic substances.
Yes, Lordship. Morphine.
Morphine.
The name of the drug is morphine.
I see. Okay, then.
And Lordship, in this case, charge was framed on 12/12/2024.
That's the one.
12/12/24.
Yes, right.
Then Lordship, dates were fixed, the charge were after the charge were framed, evidence, witness were called. On 11/7/25.
How many witnesses are listed in the charge sheet? Are you in a position? to
Eight.
say?
Lordship,
Eight, lordship.
How many? 8 witnesses.
yes,
Yes, lord.
8
This is the proof.
Witnesses. And how many examined so far?
no, none, Lordship.
None examined.
Lordship, may please to note, on 11/7/25 and 59/25, one witness was present, but he could not be examined.
Lordship, on the dated 15/9/2025, here direct mentioned that learned
Lordship,
counsel
my
for the
learned friend
accused is
complete thereafter, I
present.
come, Lordship,
Okay,
let, because she has
Okay.
probably C1 to complete,
Yes.
she has not completed. Let her complete.
Okay.
On dated 15/9/2025, which is arising out from the NDPS case number 315/2024. In this case, your lordship, on the trial court record, your lordship, 15/9/2025, here mentioned, accused Sujana Rosit is produced from custody. Learned counsel for the accused is present. Witness Diken Pegu is present. However, due to paucity of time,
Oh.
evidence could not be recorded.
It is here, this is Metro, no?
Yes, Metro.
Overloaded. Anyway, could not be examined.
Yes, lordship.
The
From
witness had come, but could not
Yes,
be examined.
yes.
Could not be
Anyway,
examined.
so that was the only date witness had come.
Two dates.
2 dates. Another date witness came,
11/7/25.
again it could not be examined.
Yes, Lordship. Now Lordship is to
This
see.
order is, this order of coordinate bench by my senior, as mentioned, that why, special courts are necessary, or exclusive courts.
Darshan to Didi.
Anyway,
Lordship, in this case, I want to rely on judgment of Honorable Supreme Court.
you have not completed, right? Have you completed?
Lordship, and 28/11/2000.
Last witness date.
28/11.
Again, not examined.
No, Lordship. I am saying that 28/11/2024. On that day, forensic report has come, Your Lordship.
Oh, yeah, yeah.
And
that-
Sarsit submitted, Your Lordship, before the forensic report, Your Lordship. Lordship, kindly, I have submitted the status report, Your Lordship, 28/11/2024. At the first time, Your Lordship, I have submitted it.
It was true. I've seen this.
Yes, 28/11/2024, and he has arrested on 10/3/2024. So 10/3/2024 to 28/11/2024, at least 235 days. After 235 days, forensic report has come. Before forensic report, they have submitted the charge sheet. And I have filed a bail petition also, Your Lordship, where is mentioned in order dated 28/11/2024. And the Narayana trial court is rejected it, Your Lordship, because charge sheet submitted without the forensic report. This is the proof, Your Lordship. But I have submitted the bail petition at the proper time.
You have referred, the petition have a interesting reference to a judgment of Honorable Kolkata High Court. Calcutta High Court.
Or is it
Yes.
In this case, what happened?
But,
I have not filed application for seeking default.
There have a division bench of judgment, yes, Lordship.
Lordship, there is a judgment of our High Court that filing of FSL report is not mandatory at the time of filing complaint. There are just so many judgments passed by this honorable court.
there's no Supreme Court judgment? There is?
No.
Yes, Lordship.
Lordship, that one judgment is there.
But how can you, send up someone for trial under NDPS without,
Lordship, here-
without the FSL report?
Lordship, here, while seizing the goods,
But I want to see division bench, I am bound, obviously.
Lordship, there are judgment of this honorable court and Supreme Court also. And they have not filed this application.
There's
seeking-
judgment of the Supreme Court that whether charge sheet submitted in a NDPS case without FSL is a completed charge sheet.
Yes, Lordship.
There is judgment?
Yes, Lordship.
Kindly
It is completely illegal, Your Lordship. It's completely
Lordship,
illegal.
allow-
Without the forensic report, we cannot say that it is ganja or what is the heroin, what is the morphine.
Logically, yes.
We cannot say
Logically,
it.
yes, but it all depends on how the law has been laid down, right?
Lordship,
For
what
the
happened?
purpose of following precedent.
While seizing the goods, the
And-
contraband were tested with a drugs detection came at the time of seizure. That was Supreme Court's interpreted that when the seized contraband was tested by detection came, Lordship, obtaining the SFL report, this is a formality that can be subsequently that can be submitted also. Here, Lordship, they have not come for the
I-
default vote.
Okay, kindly,
Default bail.
kindly help me with those judgments.
Lordship,
I will need,
today I have not brought Lordship, allow me one day time. Tomorrow I'll put that judgment.
I can also search, but I don't get time.
It's not.
Tomorrow
like
it may
to
be
do
peaceful.
research.
It taken the so many time, Your Lordship. So it's not possible. Again and again, time has taken, and again another submitted. It's not possible, Your Lordship.
But this
And
case.
where is the accused?
Lordship, this application is not for default bail. Lordship.
No, this case, this case law, I also need, this.
I'll-
case law, I also want to see this position.
Because Lordship, this point was not taken, so I have not brought this.
This position is, you're saying that there is judgment of our division bench as well as Supreme Court, Honorable Supreme Court.
Single bench, Lordship, not division.
Division
Coordinate bench.
Coordinate.
And also Honorable Supreme Court
Yes, Lordship.
saying that even without FSL, it will be a completed charge sheet.
Yes, Lordship. Lordship, this is a judgment of coordinate bench, Motiur Rahman.
And Supreme Court judgment
Yes,
kindly.
I have annexed, Your Lordship, Supreme Court judgment, page number 30, Annexure 8.
Lordship, this is not the way. First she said that she has completed her argument. Now is in between she is submitting. Lordship. Either she will complete, then I'll start after completion of argument of my land.
Page number 30, Annexure 8, Your Lordship.
This is the judgment where all they come for default bail and this court has rejected.
I have
on the
annexed
basis
this
of Supreme
petition,
Court
Your
judgment.
Lordship. What you?
Record some deliberation.
And other hand, the accused person is the local person, your lordship, and he is in custody 1 year, 7 months, 3 days, your lordship. There have no chance for absconding, your lordship. He is from the Gwalpara, your lordship. Under the Assam, your lordship.
Those aspects are there, but first let us see this default bail aspect as well as 37. You were mentioning about Supreme Court judgment?
Yes, lordship.
Para?
Page 30,
30.
Annexure 8.
No, this is the Calcutta High Court judgment.
Yes,
This is the
Calcutta. High Court.
Kolkata High Court judgment.
2024 SCC online CAL Calcutta
Calcutta.
9109.
Calcutta High Court judgment.
Reported, your lordship.
No, if some principle has been laid down by coordinate bench, either I have to follow it or it has to be referred to larger bench, as you know. So let us see the Honorable Supreme Court decision.
Lordship, today I have not brought lordship.
Yeah, it's okay. Can you manage it tomorrow? Tomorrow or day after?
Day after tomorrow.
Day after. Kindly.
Yes, Lord.
Should not be beyond day after.
Yes, yes, Lord.
And lordship, I have submitted the
Because I have not, whatever is little research I have done, studied in NDPS, any particular judgment I have not found. I must have missed this particular, because this also comes to my mind that
This point-
logically it's not complete, but what does the law say?
Yes, Lordship, and Lordship is to see whether it was tested during the seizure or during seizure or not. The purpose of filing FSL report is to see what was the nature of the drug loads. And subsequently it was filed and it was accepted by the London trial court also. And thereafter 6 date has been fixed for evidence. On 4 occasions, nobody turned up. On 2 occasions, Lordship PW1 appeared.
all that I have appeared, your lordship. All the day I am waiting
No,
for the
it's not
witness, your
hard.
lordship.
It's not the accused's fault anyway. So, your good name?
Miss Amethi. And lordship, kindly may allow me for submit the bail applications number 1364/24, lordship. In this case also, the accused person is has granted bail on 1 year and 6 months, your lordship. They are directly mentioned. I have given the underline in.
Learned
the case.
counsel
Ito did
addresses arguments at some length. The
Underline.
prosecution, within bracket, NCB.
No, Lordship, this is DRI case.
DRI.
DRI,
It's
SC
represented by standing counsel, SC Kyle, assisted by good names, M. Deka, and your good name, please. R. Hussain. Full stop. The learned prosecution seeks short time to submit a case law to the Honorable Supreme Court on the aspect of filing of charge sheet without, in the NDPS case, without the FSL report. Full stop. The prayer is allowed. This is the matter Wednesday.
Lordship.
There's an analogy with an issue of sanction, as you know, it will not be correct because sanction is a matter of cognizance. So I have had many experiences that the CBI or NIA, especially CBI and PC cases, the sanction is not come. But they submit the charge sheet. But we cannot, if I take cognizance, that's gone. Cases will be quashed. It is kept pending, and then if the sanction comes here. But here, the thing is slightly different. As you said, if there is a drug testing case, maybe.
Yes, Lord.
But if there is no drug testing also, then I think it will be
Then probably there may be some problem.
difficult. So let us see. The thing is that academically we can go on this thing, but if there is a principle laid down by Honorable Supreme Court, matter ends there.
Lordship, in serious
What-
court,
what
case,
court?
Lordship, I'll produce that judgment also. In that case said that the accused has to come within default bail at the relevant time. If the charge sheet is submitted, then the purpose of default will already frustrate.
On the 61st day or the 91st day or 181 day, the accused, as we understand, has to do 2 things: file the bail application and say that if given bail, is willing to furnish security. His job is done. Thereafter, if his charge sheet is filed, it will not be
Yes,
defeated.
that is the law.
There was a lot of confusion
Yes.
with that law, but it has settled.
Now it is,
Sanjay Datta.
now it has been settled.
And Lordship, one is my request, kindly matter may be fixed on part heart item, your Lordship. Part heart,
It will be this week only, Wednesday.
Lots,
part heart.
The matter is Sparta,
Yes.
Wednesday.
lots.
This is yours? This one is compilation? I think it's yours, DRI compilation. Can we see, or I can keep it also if you don't need it. Let's hope we don't have line.
Oh, this is mine, your Lordship.
Your
I
compilation.
submitted it.
You can take it, you'll need it.
Kindly return with me. My bad.
Production list one.
May I please, your Lordship? One minute, kind of, put a time being on it. Put a time being on it.
After some time?
DP Gusam mati diye asan akhole asan. Gusam dek mati diye asan akhole asan.
May I please, your Lordship?
Five, my lord, in this case, as per my instruction, charge sheet submitted.
Charge sheet submitted.
Charge sheet submitted on 24/9/25. Before completion.
My lord, intermediate quantity, my lord, 1.96 gram ganja. And 79 days today itself.
Heard. So.
Tomorrow, production list one to some.
Dolgaon PS case number 126 of
Someone sign up,
the
yes.
The allegation is in the FIR is about recovery of intermediate quantity of contraband in the form of suspected ganja within bracket 1.967 kg. From the shop of the present accused. The learned prosecutor submits that the accused was arrested on 25/7/2025 and since then in pre-trial detention. It is submitted by the learned prosecution that in the meantime, upon completion of investigation, charge sheet has been filed against the present accused. Considering the length of pre-trial detention and the completion of investigation, the accused is hereby allowed to go on bail of 30,000 with one surety, the like amount to the satisfaction of the concerned learned court.
Special judge.
Special Judge Dorong. And subject to the conditions that number one, he shall be available for trial, if one commences. Number two, he shall not hamper or tamper with evidence. And number three, he shall not misuse his liberty to commit any offenses, including any offenses pertaining to narcotic drugs. Violation of the bail conditions shall entail cancellation of the bail. Bail petition stands allowed and disposed of.
Obligement.
That please, your Lordship, hearing this, the application petitioner is behind the bars from 122 days, my lord. FIR is at page 16, my lord. Relevant part is page 19, your Lordship. Regarding the petitioner is a auto disco puller, my lord. And e-rickshaw puller, my lord, and he transported the modified cylinder, my lord, to the house of one of the accused, my lord, in the morning. And police have found him in the house of the said accused, my lord, that is Saramani Roskot. Your Lordship may found it page 19.
I found. This commercial quantity?
Yes, sir.
I mean,
Commercial
commercial quantity. Okay, go ahead. Go ahead.
My lord, now after completion of all formalities, I interrogate all the three apprehended alleged accused persons whom were kept at safe custody of Silchar PS. During course of interrogation, Sabiul Loskor revealed that he had delivered two modified cylinder to one Taramoni Loskor of Madhurband, and also Sabul Hussain Loskor told us that he will cooperate with the investigation and led us to the delivery of the place. Then, my lord, your lordship may escape this para, my lord, before entering. Before entering the house, I requested two respected persons of the locality, namely Chinulal Roy, son of such and such, my lord, and then Samsul Islam Borboria, such and such, to appear as independent and explain them to our purpose of conducting the operation and also serve notices to them. Accordingly, they agreed for the same. Before entering into the house, which is under construction and covered with the tin independent witness search in the body of a police personnel and found articles were mentioned in the self-search list. Thereafter, I, along with my staff, I entered the house and found two persons who identified themselves as Taramoni Loskor, 52 years of age, such and such, and Motiul Islam, that is the petitioner, the present petitioner. In this, moreover, I have served one notice under section 50 NDPS Act to both the persons and also explained them about their right to be searched in front of the magistrate and go in Hindi and Bengali. They acknowledged and they understood the contents of the notice and agreed to be searched by the team rather than go to magistrate. Also, in the meantime, Sabul Hussain Loskor recognized the face of Taramoni Loskor. That is one of the accused who was arrested earlier, my lord. He identified the Taramoni Loskor, and petitioner is a e-rickshaw puller. He only transported the modified cylinder to his house. That is Taramoni's house, my lord. Okay. And in the forwarding reports also, police has not requested for further interrogation, my lord, at page 24, my lord.
He transported the cylinders
He just from roadside to his house, my lord.
without knowing anything,
Without
according to
knowing.
your contention. But the contraband was found inside the cylinder by cutting it.
Inside the house of that accused person. my lord.
Anyway, which page?
Page 24, your lordship may found forwarding report.
No
That
prayer for,
prayer portion, that is my lord.
no
Under
prayer
the-
for PC.
Page 24. Under the above sections, sir, they are
5 days. 5 days PC.
your lordship got it.
Yes. 5 days police custody.
But not for the accused, subject present petitioner, my lord. But his bail was rejected along with other accused persons, my lord. And I have also enclosed the e-rickshaw registration certificate and bank loan certificate also, my lord, at page 42 and 53, my lord. That is in his wife's name, my lord, who is now in the affidavit, his wife has done the affidavit, my lord. At page 42, my lord, your lordship may annex at 5, your lordship may quote.
Yes. This is
That is Rusna Begum. Rusna Begum is sworn affidavit on behalf of the petitioner. That is his wife, my lord. She is his wife.
this is a monetary transaction.
And registration certificate also in the name of his wife, my lord. That is at the next page, page 53, your lordship.
Okay.
That considering the period of detention, your lordship may kindly release the petition. Since there is no allegation
We have to
specific.
see the 37 aspect.
Yes, Lordship, in the charge sheet subject on 21/8/25. So TCR received, Lordship. So it's a voluminous one. So I have not completely go through it, Lordship. So and charge sheet is not completed. Some pages were missing, Lordship. That's why, Lordship, if Lordship allow me to some time to go through the day after tomorrow, then
You can go through, otherwise I'll have to reserve it because I'll also need some time. But check the charge sheet, because if we reserve it for order and then I find that the charge sheet
Yes,
is
yes.
not complete, and it will create complication.
some pages
So
will
you,
take-
you take 2 days and then you see it.
Yes.
properly. Right? Nitin, good. Okay, the heard counsel. The accused is stated to be in detention since
10/6/2025.
10/6/2025. In connection with Silchar PS case number 603 of 25. Under section 22 Cs 1 to 5. Yaba tablets. Full stop. It is contended that the present accused petitioner is not involved in the alleged offences. The scan PCR has been received. The learned additional people, Mr. Goswami, takes some time to go through it. Prayer is allowed. Let it be on Thursday. My lord, it will be good. List matter on 1610.
Highly obliged.
May I please your lordship? The affair is at page number 13, lordship. It is a in connection with Panbajar PS case number
But it is on the
259.
case diary also, earlier 34, number,
40.
item number 40, lordship.
Okay.
So Panbajar case, that case.
That assault incident.
Yes.
Yes, lordship.
And this petitioner is identified by the co-accused and witnesses also.
And
What is his name?
Abdul Khalek. He is the person who assaulted them by a plastic pipe or rod.
my lord, so far the allegations is concerned, lordship. I have already cooperated with the investigation. I have remanded for 5 days police custody and thoroughly interrogated, lordship. And I was there. I'm not denying the fact that I was there because my source of livelihood is the shop. And I did not commit any assault over the alleged victim persons, lordship. And lordship, there are many persons, and at this stage, it cannot be said, specifically said that this person assaulted that person. Now only the co-accused person may allege me, lordship, but it is the matter of trial, lordship.
Allegedly group assault anyway, so I think the investigation, if I remember correctly, the investigation said that this
FSL
chemical report.
Chemical report is pending, lordship. It is awaited.
And lordship.
He was arrested on the same day, 9/8.
Same date, 9/8, your lordship. And lordship, already this honorable court already granted a bail to the other accused persons.
Item number 40.
The learned counsel submits that he denies the involvement of the present petitioner in the offense. The case diary has been received, and the learned additional PP, Mr. V.P. Goswami, submits that there are incriminating materials against the present accused, who, apart from being FIR name, has also been implicated by witnesses as having participated in the assault upon the victim. And that he had assaulted him with a pipe. However, the investigation has progressed sufficiently and stated to be pending largely for collection of the forensic report. Several co-accused, including several FIR named co-accused, have been granted bail already. The present accused was arrested along with others on 9/8/2025, and since then is in pre-trial detention. It is also submitted from the petitioner side that during investigation, he was also taken into police remand for 5 days and custodially examined thoroughly. Keeping the aforesaid facts and circumstances, also the aspect of parity dash. The accused is allowed to go on bail, same conditions. Same condition, 30,000 once you it.
Highly understood.
Twenty-nine, something. From South Road.
Yeah. To the regular bail matter, today is 89 days.
89 days.
89 days. Section is 64, rape, my lord. CD is here, my lord, so there is no.
Case
chance.
diary is here?
Yeah, we have received the case diary.
Okay, you are appearing for information. Come forward.
Now, only on the length of detention now, my lord, it will be there. The lordship will find FIR is page 9. He was arrested on 16/7/25. Today is 89 days.
Can you see the 164 statement?
Yes, implicated fully, Lordship. Fully implicated, Lordship. Lordship can go through it for sure. I have.
On merit, my lord, at this stage, I think, my lord.
It's okay.
Actually, seal, yes. ma'am.
Understand.
I'm only length of detention.
The concern is the. Question is there and state to be uncle, might be relative.
Yes, relative, nothing. Neighbor, my lord. Tomorrow will be 90 days, my lord, tomorrow. So
Oh,
tomorrow will be 90 days.
oh, that aspect is there. Yes. Okay. That aspect is there. Any submission from your side? That aspect, tomorrow it can be filed, but that aspect is there.
But otherwise.
It is here, so they cannot file. my lord.
Some concern, okay, let him go, but there is some concern about her safety because. he
Yes.
knows person.
My lord, that I.
Kindly impose conditions.
My lord.
Because he's a neighbor.
That is the thing. And senior counsel, assisted by Ayush or DP Goswami Lanet additional. Oh, sorry, I forgot how.
Sir. My lord, actually, a lot of things have not been mentioned in the petition or my objection, my lord. For instance, that the informant came here, my lord, in the court premises and he broke down, my lord. And that is something that people cannot fake, my lord, in my opinion. And my lord, in brief, the matter is such that this person, my lord, the accused, my lord, he was trying to persuade this woman to fall in love with him, my lord. First, he tried to give her money. Then he tried to give her gifts. And upon continuous rejections, my lord, he walked into her house, my lord, found her alone, my lord, and at night.
Is that non-compliance of, my lord?
Ground of arrest was
Grounds
not.
of arrest, but my lord, here, your lordship may kindly peruse page 24 of the petition, my lord.
24?
Page 24. So I am trying to find out, my lord, page 24 of the petition, my lord. That is.
Her husband went and disappeared, no? That's the basic allegation.
Yes.
Basically, my lord, husband, my lord, informant husband, my lord, when somebody shot at his head. In the FIR, two miscreants, unknown miscreants, have made the allegation. And regarding me, my mobile number was found within the locality of the Bongaigaon district. It's a big district, and that is the only allegation, nothing, only CDR. And second thing, my lord, based on our High Court has given bail, my lord, on the same FIR, the prime accused were released, in page 147. So I am relying on that page 147, bail order, and 155. Page 147, your lordship will find. The main accused was Nilima Kasari, who is my auntie, my actually aunt. So they suspected that I am having a call regarding some conspiracy. Basically, she is my aunt. So I have stated that, and she was also given bail on the point that your lordship will find this paragraph, page 153. No ground of arrest was given, page 153, paragraph 15. And that was also similar in my case, my lord. Same to same, they have mechanically served a notice, my lord, without giving any ground. I have also annexed my notice and memo arrest. Also the notice of the this Nilema also. It is absolutely same to same, my lord. That is the thing, my lord. When we are being produced, my lord, basically we are arrested on 26, my lord. Sorry, my lord. FIR was on 26. Then after 5 days, I was arrested, my lord, without mentioning any arrest. Merely on suspicion that I am having my mobile number was within the locality.
That will,
Yes.
only that cannot, be the
Yes.
factor. But anyway, one thing I want to know, how many people were sent up for trial?
My lord, already status report is also there. I have flag mark, my lord. Out of total 78 witnesses.
Yeah, 78 I remember.
Total, my lord, 12
to-
PW is already examined.
Examine. No, no, how many accused were sent up for trial?
Accused, my lord, total number of accused, my lord.
Can kindly check.
Yes. Four.
They were forwarded were 8.
Yes, my lord.
8
Yes.
people were forwarded, but
Yes.
if you have the charge sheet,
Yes.
charge format, then you can check from there.
Yes, my lord, I will point out, my lord.
I am also checking.
Search sheet is at page 52 of the petition, my lord.
No, sometimes plus minus is also there at the level of charge. Best will be to see the charge format.
Yes, ma'am.
But if there's there's non-compliance with the notice, then many
Nothing-
details will
yes,
not be
Not
necessary.
non-compliant, that's why I would like to point out page 23 of the petition. All I am trying to find out the notices, my lord, but my lord, I find it
Well, I have
difficult to
annexed the
understand.
notices, my lord. That is.
So could you find out how many accused are facing trial in this case? Because I want to know that how many have got bail?
So far, my lord, from High Court, 2 of them have got bail. The
Two of them?
main allegation against the 2.
My lord, a detailed list is there, my lord, in the first portion of the LCR, my lord. A detailed list is there, my lord.
LCR, not.
LCR, my lord. A detailed list. None, my point of view.
Sorry.
মুখ দিয়কচোন মই এইফালে চাই দিছো লিষ্ট এখন আছে চাই দিয়ক main
Order sheets are not necessary.
no my lord, in the main file one list my one is single file cover.
Oh, I think I have got.
Detail list oh নহয় নহয় মুখ দিয়কচোন এইটো
I have annexed the search sheet, my lord.
না ইটো ফাইলত আছে নেকি চাওকচোন নহয় নহয় নহয়
I think 8 people. 8. 8 were forwarded.
Yes.
And 8 were charge sheeted, 8 are facing trial.
Yes.
All, no?
Yes.
So 8. So 2 have got bail, right?
2 got bail, my lord.
and
But
regarding
anyway, then let us come to this
Yes.
aspect.
regarding that aspect I would like to point out
Yes, now you tell me.
but I am trying to find out in the LCR, but I have not. Your lordship may kindly page 24 of the petition filed by the petitioner.
Okay.
That is the forwarding report. Forwarding report,
Page 24.
page 24. That is grounds of arrest, my lord. Page 24 is the relevant portion I am pointing out.
28 is the original copy, my lord.
Let
Page
us see the original copy.
Yes, my lord. 28.
Page 24, my lord, ground number, last portion, prayer portion after ground number 8. I therefore pray before your honor not to enlarge the below noted accused person on bail at this stage of for the interest. The grounds of arrest have been communicated to the arrested accused persons and their relatives by issuing notices. The below noted accused person have been, so only ground here taken is that no grounds of notice communicated to along with the grounds of arrest, but here it is specifically mentioned that grounds of
Notices were
arrest.
given?
Yes, along with
But we are not notices.
I am trying to find out in the record.
But it's not there.
Not there.
Not there.
It's not there.
What is there?
The coordinate bench.
Yes, yes.
Bail order.
Yes, yes,
if-
I have gone
If
for.
they were arrested at the same time, then
Same time,
perhaps.
my lord. Same day, my lord.
I have
And
flag mark,
also, my lord, The second remand order says that my custody is not required, my lord.
But
Page-
why in the
page
grounds of
35.
just, my lord?
Page 35, your lordship, second remand, it says that my custody is not required, my lord.
Yeah, 50 notices he has annexed. He has annexed.
Yes, 50 notice is there.
But
that is-
50A will also be necessary. That is
And-
not there.
But my lord, difficulty, why in the forwarding report at the, on 1/7/2000, they specifically mentioned that grounds of arrest along with notices were communicated to, not only to the accused, to the relatives of the accused. But those things are not there in the
Yeah,
record.
these things make difficult for the prosecutor.
Yes, yes.
But it's not there.
Now, I am relying on that judgment of our coordinate bench, my lord, where it was paragraph, page 150, your lordship will see, that will clear their case match, page 150 of this bail application, para 9, my lord. That is what the query of the learned PP, my lord, page 150, my lord, for the moment. A bare perusal of the para 9, my lord, may I read? A bare perusal.
No, I've read it.
Yes, my
I've gone through it.
well, I'm basically, my lord, facing incarnation, my lord, for last, and that is in violation of Article 22, my lord. That is the thing, my lord. I'll face the trial, my lord. That is the thing, my lord. And I've stated seized by auntie, and merely because I've been, there is a call, how can they say, my lord, that it is regarding some conspiracy?
That aspect, could you see that the only, his contention is that the only material against him is
that
mobile
material-
location in the district of Bongaigaon.
Not only the mobile location, my lord, that as per grounds of arrest, I think that he has provided, my lord, the one of the accused, my lord, the present petitioner deceased, my lord, wife is also an accused, my lord. And she has provided an amount of rupees 1 lakhs to the present petitioner, my lord, for
Statement, only
for
statement.
executing the entire plan.
Only statement of
Yes.
co-accused, no material, my lord. That is the thing, my lord.
Regarding other accused person, because that, my lord, incident occurred in a shop, my lord, and their witness, from their deposition, it is, two accused persons were identified.
We did not have much scope for going into merits also because
Yes,
of this
yes,
aspect. Anyway, but
Yes.
subject to conditions.
Yes,
Lordship,
regarding grounds, communication of the grounds of arrest, yes, I pointed out page 24 grounds of forwarding
mentioned,
report, forwarding report that is there, but
uh,
from the record, I have not found.
You have to mention in
Section
writing and that are not given.
In 24, the IOs were still learning actually.
Yeah.
I mean, they were not very adept. Yes, anyway, so 1/7/24.
And
He's in
specific-
custody since 1/7/24.
My lord, my lord.
And
469
specifically
days.
mention about relatives also, but regarding relatives, my lord, I have not.
Yeah,
Specific case, my lord.
483. Fact is fact, and that's always
Yes, yes.
fair about facts. Always helps. 483 bail application. On the so and so. Used Manoj Kumar Basumatari, alias to Lihuland, who is in custody since 1/7/2024 in connection with Sessions case number 73 of 2024. Arising out of Bongaigaon PS case number 226 of 24 under so and so sections. The said case is at the stage of trial wherein eight accused, including the present accused seeking bail, are facing trial. 78 witnesses are listed in the charge sheet, and so far 8 witnesses have been examined. The learned counsel mainly contains that the grounds of arrest were not furnished in the required format, and that no notice was also issued to his relative. The learned additional PP submits that there are incriminating materials against the present accused as well. It is also submitted that as per the forwarding report, the accused and his relatives have been duly noticed. However, on perusal of the notice under section 50 CRPC, within bracket, as it existed then, I find that the same would not meet the standards of same would not meet the requirements regarding grounds of arrest as laid down by the Honorable Supreme Court in the case of Prabir Purkasta and Bihan Kumar. to notice come উঠাই দিব কৈছো short 50 inches here. Show you. Further, the learned additional PP fairly submits that he could not locate the notice under 50A CRPC. The learned petitioner counsel has also submitted an order dated 4/9/25 passed by coordinate bench of this court granting bail to co-accused on the ground of such non-compliance after referring to Vihan Kumar and Pravir Prukast. In this regard, it is submitted that 2 out of the 8 accused have got bail. In the given facts and circumstances, and in view of the principles of law laid down by the Honorable Supreme Court, the non-compliance with the requirement of grounds of arrest in the notices as laid down in the said decisions, aforesaid decisions, entitles the accused to bail as his continuing detention is untenable. In such view of the matter, the accused, so I'll impose same kind of conditions. You can take it from here, 50,000.
Yes.
Sorry.
Same
50,000 with one surety of the like amount. He has given 2 sureties. I usually give 1 surety, but 50,000 with 1 surety of the like amount. Satisfaction of the concerned learned court. Session Judge Bongaigaon. Subject to the conditions that number 1, he shall be available during the remaining trial. Number 2, shall not hamper or tamper with evidence. Shall not threaten, harass or harm the informant or her family or any witnesses. Violation of the bail conditions would entail cancellation of the bail. Bail petition stands allowed and disposed of. Okay?
Obliged, madam. I am deeply
So
obliged.
the moral of the story is don't be intimidated only by the size of the fine.
Yes.
Sometimes I have got this lesson from advice from my seniors, especially with regard to civil.
Yes.
Because there are many unnecessary papers in between.
Yes.
So one of my seniors told me, first you make the file more friendly, then you take up, then you go for a civil matter. Good advice.
39. May I please your lordship, a regular bail application, my lord, 56 days behind the bar. But first, it is a case of the section 7 of the Essential Communities Act. But some sections have been added that is the organized crime. To my submission, my lord, that all these sections of organized crimes are not applicable. The allegation is that some diesels were recovered from a house. Diesel. Unauthorizedly, they were stocked it. But you know what, the unpalatable truth. These are being purchased from the oil tanker while they passes, my lord. And some people are earning in that way. So, my lord, enough is enough 56 days behind the bar.
7 is, I think, bailable, right?
Yes, bailable, my lord.
Case diary has been received. Kindly see the progress of investigation.
56 days already spent.
Oh. Yes, my lord. He is the owner of the Godam, my lord, from all those, my lord, articles were
Diesels were allegedly recovered.
Reports are there, no doubt.
Yes.
Investigation, how much is the progress?
Investigation, my lord, almost already
My lord, if
substantially covered all the.
we'll face the trial, my lord.
Otherwise, one report from the IOCL also received, my lord, from to the report letter, my lord. That vehicle, my lord, which was also seized along with those, my lord, diesels, my lord, is that is, my lord, registered under IOCL for supplying of all these diesels, my lord. And from the actually driver is also accused. That driver from that, my lord, vehicle, he.
Yeah, they may have complicity.
Yes,
They are doing it.
Yes.
That's why I have given this section of organized.
This is a racket, my lord.
DNS section
Yes.
is there. Anyway, can I have a look? Third, see this was learned counsel assisted by additional PP, P. Botaku. The 3 petitioners herein are seeking regular bail under 483 BNSS in connection with Silchar PS case number 842 of 25 under section section. They were arrested on this act 25 and presently in judicial custody. Honored Council, Mr. Biswas submits that while section 7 of the EC Act is available, but the provision, which is the organized crime section?
That is a 1113, 1114, 1115, 1116, 1117.
The
All these
provisions,
sections.
the provisions of BNS given pertaining to organized crime may not be applicable. It is submitted that in any case, they shall face trial and seeks bail at this stage. Learned additional PP submits that investigation has revealed implicating matrix and involvement of a racket in these illegal activities. Is submitted that he is not the driver, no? He is the driver.
No, he is the one is the owner of the godown. my lord.
Owner of the Goran,
The-
where it
the-
was stopped.
Tapan Das, petitioner
Implicating
number 3
materials against
is the owner
the
of the
driver,
godown.
the vehicle as well, tanker as well. Nevertheless,
Driver of the tanker is not the petitioner, my lord.
He he is not here.
He is not.
There is another case for her.
nice. It will not happen. You may be prejudiced.
And other persons were arrested from the spot, my lord, along with the petitioner number 1 and 2.
Police remand was given, huh? They were examined.
Yes.
Seen the progress of investigation. How many days, sir? You said
56 days
56 days. No, no, they, because
from
there's a-
20th of August.
because there's a endorsement that there is a prayer for police remand. But this will not be there. This is
Yes.
is long back because in 60-day offense, up to 40 days they can seek.
Yes.
Exactly.
But person has to be in custody.
Custody.
So that can be a ground for anyway. So the organized crime section will be 90 days, I think, right?
Yes, 90 days, my
It will be 90 days.
90 days.
So in that case, it will be up to 60 days they can file.
Yes.
They can seek police
Yes,
custody.
correct.
But this is a old endorsement.
No, no, ultimately, basically, it is a case of essential commodities act.
Yeah.
And
The only aspect of organized racket is give some, some gravity, more gravity to it. Anyway, this is a whole endorsement, I think.
Yes.
Very 28, anyway. Considering the length of detention and progress of investigation, the accused persons are allowed to go on bail of rupees 30,000 each with surety of life and money each to the satisfaction of the concerned learned court. The court will be CGM
Silchar.
Silchar. And subject to the conditions that number 1, it shall cooperate with remaining investigation. Number 2, they shall not hamper or tamper with evidence. Number 3, they shall not involve themselves in any illegal activities or offences. Return the case there, bail petition stands allowed and disposed of.
Diplo.
43. May I present, Chief?
Yeah. That matter. Let us see what.
No, we have not received any instruction, Lordship. But I have informed the office that CD was earlier here. On 26/9, CD was taken back for updation. We have tried to communicate, but not, we have failed to communicate, Lordship.
What is the?
My humble prayer before Lordship is that 3 of the co-accused has already been released on bail. 3 of the co-accused have already been released on bail. Number 1 is the main accused. His case is somewhat different. or did not inform me the grounds of arrest. But numbers 7 and 8 are exactly similar to me, under similar circumstances and similar rule. And Lordship may kindly see page 8 of the FIR. Lordship may kindly see page 8. Last
Pre-
part of
The present petitioner is accused number
accused number 6.
6, right?
Lordship.
Unusual delay, and it's a very difficult question, actually. Third, is the essence from a learned counsel for the petitioner. And also DP Goswami learned additional PP. The case arose out of FIR dated 27/6/2025. Naming eight accused persons, including the present petitioner seeking bail hearing, namely Diwan Nazmul Haq. The gist of the allegations is about causing homicide of the father of the informant.
If Lordship allow me to submit something, Lordship. So,
Oh, you are for the informant?
yes.
Oh.
The period of the case, there are 2 persons here, I find the order, Lordship order. Their bail was rejected, Lordship. After going to the case diary,
After perusal of.
based on the case diary. So
So
he's,
case diary will be necessary.
he is a FIR accused. So my humble, it's an anticipatory bail, Lordship. My humble plea before Lordship, that wait for some time, I will communicate, and if any. report or
Unusual
anything-
delay actually. Anyway, so I think however allegations, it is the learned counsel. 2 were granted bail.
Lordship.
Yes, learned counsel submits that two of the FIR named accused have been granted bail by this court. It is also pointed out that the direct allegation against the accused, the direct allegation of homicide is attributed to the accused number 1. However, it is also alleged that the homicide was committed by accused number 1 with the advice and cooperation of the other accused. Full stop. The learned additional PP points out that 2 of the co-accused, the bail of 2 co-accused was rejected by this court after perusal of case diary. The instant bail application has been pending for case diary since 1/9/2025. Full stop. That is the problem, actually.
Yes,
This is very naturally, we very aggrieved. The diary has got lost or what in between.
Earlier it was here, Lordship, that's why on another case, I think it was sent for updation on 26/9/25.
My humble prayer is that interim bail may be granted pending this receipt of CD.
So which 2 applications were allowed
Yes, Lordship.
and which were rejected?
This, it was.
And I have to hear informant also. You are for the informant, right?
Yes.
Please submit.
Yes.
This creates a difficult situation for the court. Otherwise, there are materials, but it's so long.
Lordship.
It is, I can always adopt a coercive measure against the IO. But that's but a court should not be compelled. I don't prefer to. It should not be compelled. You should not, just taking it casually because the court is stuck. This was rejected. Diwan Hanif Ali. The IO is directed to positively send. It will not be justified to give interim.
At this stage, Lordship.
It is surprising that as to why the IO has not sent the case diary, despite elapse of several days. The IO is directed to positively send the case diary on or before the next date. The IO shall also submit a status report regarding the investigation. Status. A copy of this order shall be sent to the OC of which police station?
Patasakusi.
OC of Patasakusi police station. When should I fix it? Monday?
Lordship,
When?
this one, Wednesday, 22nd, 23rd,
23rd, 24th.
24th.
24th. Nowadays, things have improved. Earlier, this used to be some big problem, but nowadays CDs come quite fast. Surprisingly, some miscommunication. Is
Yes.
tied up with some other DT because CD can be sent
That is-
to someone.
They communicate.
CD can be sent through someone. I'm not seeking,
Yes.
this time I'm seeking a status report. This time.
Yes, made a communication on 10/10, Lordship.
Status report. Otherwise, the CD has to be packed and sent. No? Also heard so and so for the learned counsel. Your good name, please. For the informant.
Nineteen 29 of the consent.
CD not received, right? Diary is received.
No, there is not.
None appears. On third call also. The case diary also is not received. There's an interim order, that's the thing.
Yes, madam.
Should we can fix issue press requisition for the case diary. The interim order. The interim order passed by the order dated so and so. No, where is the interim order? Where is the interim order? ভুল হয়েছে নাকি? Order নাই শুনি।
My lord, here, my lord, is the case of POXO, my lord.
There is no interim order.
No interim order, my lord, the service report is,
Erroneously it was listed, it was mentioned, erroneously it was.
my lord.
But, that's why I prefer to give the date because it makes you check, cross check.
Yes, my lord, no interim, my lord.
No interim, but it was last two orders, it was by mistake, it was.
My lord, my lord.
Upon perusing the case record, I find that নালাগে কোনো। You wanted to say something?
Yes, my lord, that's because it's a POXO, my lord, that is service report is also
That is
awaited, my
for
lord.
revenue,
That
of-
also we have to take, my
office
lord,
note.
instruction, my lord.
The office notice, scan copy, serious. The learned additional PP shall also take, Mr. Boysos, shall also take instructions regarding regarding service upon the respondent / informant number 2. If I had not checked the date, then I would have also made the
Yes,
same
my lord, yes, my
mistake.
lord.
That's why
my lord.
I have
Yes,
learned from experience.
Yes,
It
ma'am.
helps to check the date.
my lord.
So it compels yourself to
Yes, my lord.
cross check. Because we course of work, we can make this.
So, my lord,
When should I?
a date may be fixed, my lord.
Yes.
It's from Hatigaon, my lord. We
Mhm.
will,
Next Monday,
next Monday.
23/10. So this
Yes, my lord, 24th, my lord.
24.
24th, my lord.
Addition item 21.
Bail hold also. Orders are saying, only admission is there. Yes.
May I please, the lordship? Lordship, in this case, lordship,
Deliberations.
the accused did not got an opportunity to reduce his DW lordships. That is the case, lordship. The page 11, that is the impugned order, lordship. Then at the stage of argument, the accused was filed at the petitions that he is he may be allowed to reduce his DW lordship. That petition has been rejected. But lordship, in this case, lordship, court is very much aware that one step did not follow followed by this trial court, Lordship.
Just a minute. The impugned order is 2510.
Yes, Lordship.
Give me 2 minutes, I'll just go through it. Fix for argument. Okay.
Lordship, in this case, the law is very much clear, Lordship. The court is very much aware that
There's a, I think, judgment where even if the answer is negative in 313,
yes,
you can. Do you have the judgment?
Lordship, today I have not gone.
I
Lordship,
also don't remember, but I think
Yes,
there is a
Lordship.
case.
Lordship,
You're appealing for the?
That's for number 2, my lord.
Okay. just one.
Lordship,
So we have both the counsel and the prosecutor to assist.
Lordship, in this law is very much clear, Lordship, that after when Lordship 330 in statement has been recorded, thereafter Lordship a hearing has been conducted, and after hearing Lordship is if the accused is discharged, acquitted, then Lordship then defense statement, defense witness stage is come, Lordship, and after defense statement, Lordship, then a defense witness, then Lordship it come with argument stage. But
Actually, this was fixed for argument because in the 330,
yes,
in the it was
yes,
answered
yes, Lordship.
for format, the answer
Yes,
is no, but question is, can you suppose after that, if he changes his mind, will you bind him to that format, that statement, or you'll give him some flexibility?
Lord-
That is the-
Lordship, here in this case, Lordship, whatever I have stated in my defense statement, some question is yes or no, Lordship. Whether that it is a technical ground, Lordship, whether it is a technical grounds, if a victim will be suffered, accused will be suffered, or accused will not be get an adequate opportunity to defense and get a fair trial, Lordship. So on the basis of on the Lordship, my submission is that, Lordship, the Lordship, for the interest of justice and Lordship, for the for a fair trial, Lordship, a opportunity may be given, Lordship, to the accused to adduce their witness, Lordship. Then, Lordship, it will not be suffered it will not be harmed, Lordship, to the prosecution's side, Lordship.
Can I see your application before the court?
Lordship.
Is it-
Lordship. Lordship, that is page
Actually,
15.
see, I have not arrived at a decision at the moment, but if you see, the trial court was also justified in its own way, because
Yes.
all pending cases, there's
Yes, my lord.
it's a
Incident-
court level as well as systemic, systemic commitment.
Yes, incident was
to
took
finish
place
the case.
2020.
So in a way, the court was also justified. Anyway, let us see your application.
Lordship.
before I come to it. Petition. no?
Yes,
20
Lordship, the page 15.
Got it. No, this has been reflected.
Yes.
This has been reflected.
Lordship, here, what happened, Lordship, there is a close cases there. That's why, Lordship, initially, Lordship, the accused persons was not, why did not, he replied in negative, as because, Lordship, he, in this petition is reflected that he has applied for certified copy of this analogous case or cross case, that did not supplied by this concerned court. And ultimately, Lordship, that fact also reveals in these petitions. And ultimately, Lordship, when it came into during the hearing, Lordship, it came into knowledge, or it is required, Lordship. It feel that it is required to adduce their DW, Lordship. So that's why, Lordship, a opportunity may be given, Lordship.
But that case which has been my learned friend referred, my lord, that case already been disposed of, my lord. Cross case already been disposed of.
Go into that. We'll
My-
just
my lord.
go-
My humble submission is that, my lord, matter of 2006, my lord. Incident was took place 2006, my lord, old matter, and trial was started 2012, my lord. Almost, my lord, 20 years, my lord. And they were given the ample opportunity by the trial, my lord, trial court, my lord. Both the accused were asked whether they are interested or not. They are replied no, my lord. Now they are filed the application on the date of argument, my lord. That is a totally afterthought, my lord. Totally afterthought, just to delay the, my lord, trial, my lord. Your lordship will find the provision, my lord. BNSS, my lord, your lordship will find the provision 256, my lord. 256, clause 3, my lord. PS, my lord, your lordship 176, my lord. BNSS, my lord.
Lordship, kindly see this as CIPC, Lordship, as because this case was conducted under CIPC, Lordship.
Contents are same also, because this is.
Yes,
not-
content was yes, same. yes.
It has
Corresponding
not been
section, my
changed.
lord. Yes, my lord.
Section 230.
256, my lord. BNSS, my lord. Subclause 3, my lord.
Okay.
My lord, may I read, my lord? If the accused applies for the issue of any process of for compelling the attendance of any witness or production of any document or things, the judge shall issue such a process unless he considered for the reason to be recorded that such application should be refused on the ground that it is made for the purpose of vexatious and delay or defeating the ends of justice, my lord. It is the matter of 2006, my lord. And opportunity was given, their answer was negative, and thereafter, they know that they will be convicted. Thereafter, their counsel's suggestion it is that.
Lordship, in this case, Lordship, whatever my friend is referred, subsections 3, before going into the subsection 3, can you see the section subsection 1, Lordship? That is the main thing. That my learned friend is referring the subsection on 3 is that, Lordship, a person is applied, made an application for issuing a summon. That is come into the next part, Lordship. The first part will not come. The first part, Lordship, there of course. That
So
first
this is
part.
conducted under CRPC.
Yes, Lordship.
Then let us see the relevant portion of.
Yes,
CRPC.
Lordship. Lordship, kindly see, Lordship, my
CRPC, what will be the section?
Lordship, sections before, Lordship, kindly 231, maybe come first.
Around that.
233 hobo.
Not 31, may come first 231, Lordship.
No, this is entering upon the list.
Lordship. 231, Lordship, deals, Lordship, is
That's
saying that
okay.
evidence
Acquittal.
of the prosecutions.
When he is not acquitted, then the.
Lordship. Then, Lordship, it come in acquittal, Lordship. And then when it's not acquittal, Lordship, then and Lordship hindering upon the defense. Then
Just one. Okay. Anyway, so you complete your. So one thing I want to know, when was the 313 done?
when, Lordship?
Kindly help me with the.
Yes,
date,
Lordship.
both learned friends. Petition was filed on 22/8.
Yes. Lordship, it is done 6/9/2024, Lordships.
6/9.
2024.
22/8, no.
6/9/2024, it is a defense statement. Then, Lordship, the petition was filed 25/10/2024. That 15 days, near about 15 days back, Lordship. Lordship, in this case, Lordship, my limited submissions, Lordship, that if fair trial will not be go, Lordship, then Lordship, accused will be.
See the learned prosecution, you want to assist? See, assuming that there is no contrary decision of Honorable Supreme Court, this is the thing that though we as a matter of procedure practice,
Yes, Lord.
we incorporate that question also in the 313.
Yes.
that whether you'd like to adduce defense
Yes,
evidence.
yes.
But the statutory section does not say so.
No, yes.
That is what
Yes.
I again just refresh myself.
Yes,
313 only says that he shall be examined.
Yes.
Generally about the case.
Okay, Lord.
Generally about
Yes.
it. Incriminating circumstances have to be put.
Absolutely correct.
Thereafter, it does not necessarily have to be in that 313 format.
Yes.
That question. It
Yes.
may be also, but it may not be. It's not necessary. Then he's called upon to give a statement. And if he does not do, then it proceeds to
Yes, Lord.
argument stage. But so even if a person, again, I'm repeating, assuming that there is no contrary decision, higher court, even assuming, even if the accused says no in that format, and then that cannot be so much binding. However, that may be the general principle.
Yes.
But how you apply it will depend upon the facts of the case. How old and how later he has. That's why I asked this question, that when was the 313 file? Because one of your contention is that it's an afterthought. So to determine, that possibility of it being an afterthought, this aspect has to be seen. 2510 and 69. So anyway, kindly, Mr. Boysoff can.
Yes. My lord, here, my lord, there is the impugned order, that is 2510/2024. That is in my lord, page 17, my lord. Already, my lord has gone through that, my lord.
I've gone through.
Yes, my lord. So, my lord, here the case is of, my lord, this session case number 194 of 12, my lord,
Very old.
2012, my lord. Very old, my lord, and 24/25/10/24, my lord. This petition is filed, my lord. That petition is also annexed, my lord. Already, my lord has gone through that also, my lord. Now, only, my lord, the question, what I understand, my lord, from my limited understanding, is that whether, my lord, after, my lord, so much delay, after completion of the 313, my lord, whether, my lord, this, my lord, DW, my lord, appearance of the DW.
That is what he's saying.
Yes, my lord. Whether, my lord, that can, my lord, there is a kind of, my lord, new things, or, my lord, it's a kind of repairable things, what my learned friend has stated, there is the afterthought. That part is there, my lord. My lord, I have gone from some citations, but right now I don't have, my lord. So if my lord may allow me some time, my lord, regarding on that point of law, at what point of time, my lord, that can be allowed or not, then I can find all those, my lord, citations.
I think, if I remember correctly, it can be allowed.
My lord.
If I remember correctly.
My lord, my lord.
But exact how it has been laid
My
down,
lord.
that I have
Yes, my lord.
forgotten.
The part of ratio, my lord.
We should have it actually in front. of-
Yes, my lord.
with some technology.
I'm finding that
Fingertips,
those case laws only, my lord.
Photos,
But
otherwise-
right now I am not getting. But some cases that only that point, my lord. Otherwise, my lord, obviously, my lord, right? If the question of right, then for both the sides, my lord, from the accused and the same time for the victim also, my lord. That is always there, my lord. Here only, my lord, the fact, my lord, when it is rejecting, my lord, there is the learned session judge, my lord, they stated, my lord, those point that, my lord, in the below of that, as far as adducing DW evidence is concerned, a question was put to both the accused persons while examining under
As I
one.
said, the court was justified. in
Yes,
its own
my
case,
lord.
Definitely.
313 CRPC, and that if they intend to adduce evidence against the question, both the accused persons replied in negative. This case is an all pending. Now, my lord, regarding that question is put, that is on, my lord, there is a 313, that is the 313 is on, my lord, that is 6th day of September 2024, my lord. My lord. But, my lord, they are also, my lord, in that, my lord, 313, that is categorically stated, my lord, do you want to adduce evidence? Then the reply was no, my lord. That is in my lord, question 12, my lord.
Mr. Hawk, additional learned counsel, you're good. Wonderful. Number 12, 12, 11, 24 order tas. Very basic second para. There is also a stay, no?
Yes.
The
Proceedings.
right order dated 12/11/2024, further proceedings in sessions case number 194 of 2012, pending before learned additional session judge Dhubri, is under an order of stay granted by this court. Full stop. As already stated at the outset, the revision petitioner is aggrieved by rejection of his prayer, subsequent prayer for examining defense witness. I have perused the impugn order dated 25/10/2024. The learned additional PP, as well as the learned counsel appearing for the informant, contains that in the examination under 313 CRPC, there was a question, to the question regarding defense witness, the answer was in the negative. And the case is an old pending case, and therefore there is no infirmity in the impugn order. The learned counsel for the informant further submits that the prayer to adduce defense evidence is nothing but an afterthought made to delay the proceedings. Undoubtedly, the case is an old pending one, and the learned trial court is endeavoring to dispose of the same. Under next paragraph, under the provisions of section 313, you can sit down. Please have a seat. Section 313 CRPC, as it existed then. This was in 24, right? So I think it's a BNSS, I think. 24?
No, my lord, it's an old pending case, my lord.
Oh, at that time.
Yes, my lord, that is a mother still
Proceed
going on, my lord,
examination.
2012, my
No,
lord.
no, when the 313 examination was done on 25/10,
No, Lordship.
6/9/24.
6/9, yes.
24.
BNSS. 1st July.
No, Lordship, it's not BNS, as
My-
because Lordship.
As per that, my lord, the
C-
CRPC, because my
C-
lord is pending from that period, my lord.
Okay. No, yes. Sometimes we mix up, yes. Last do the word. Oh, as per the provision of section 313, as it existed then, dash after the completion of prosecution evidence, it is mandatory for the court to question the accused on the case. The interpretation of the said provisions in a catena of decisions rendered by Honorable Supreme Court means that the incriminating materials have to be put, all the incriminating materials have to be put to the accused at that stage. Full stop. From the statutory provision, it does not appear that a question regarding his defense evidence has to be put. Rather, the next succeeding section provision of rather section 333, 233
Yes.
Provides that if accused is not acquitted under section 232, he shall be called upon to enter his defense. And in the absence thereof, the court can proceed to the stage of argument envisaged under section 234 CRPC. Stop. In my considered opinion, in examination under 313 CRPC, present section to DD. Even if an accused answers in the negative to a question regarding adducing of defense evidence, there may not be bar in allowing a subsequent prayer for adducing defense evidence. Full stop. Full stop. Thus, such a prayer can be allowed at a subsequent stage in principle. Full stop. However, whether it is actually done so would obviously depend on facts and circumstances of the case, and also the satisfaction of the court, and also upon satisfaction of the court that the same is not by way of delaying tactics on part of the accused. Undoubtedly, the present case before the learned trial court is an old pending one, and as already observed, the learned trial court with an endeavor to expeditiously dispose of the same dismissed the prayer of the defense. It appears that the examination under 313 CRPC was conducted on 6/9/2024, and the petition filed by the revision petitioner as accused was done so on 25/10/2024, which came to be rejected, giving rise to the present proceeding. Full stop. It is also clear that the said application of the defense seeking to adduce defense evidence was its first subsequent prayer after the examination, after the 313 examination. Giving a sufficient opportunity to the defense is an aspect of Article 21. Full stop. At the same time, speedy trial, from the point of view, speedy trial and adjudication of criminal case, from the point of view of the informant/victim, is also one facet of such fundamental right. Though the same accrues to the accused as well. So in a situation like this, the competing interests of justice have to be balanced, and an effort has to be taken to take a fair decision. Full stop. The learned trial court was justified in its own way in passing the impugn order dated 25/10/2024 on the grounds stated therein. Nevertheless, I'm of the considered view that by way of balancing the competing interest of justice as mentioned above, the revision petitioner as accused can be given a limited time frame to adduce defense evidence, whereafter the case can be disposed of. Yes. Accordingly, despite the aforesaid observation regarding the impugn order, the same is interfered with. The When is the next date fixed?
Lordship,
Anyway, so. The revision petitioner as defense before the learned trial court shall move an application within 10 days,
Lordship, on the next date, Lordship, if you fix.
on the next date, or you can file it before also. And in the meantime, they can issue a summons.
Yes,
you know,
Lordship, and the-
expedite. When is the next date? They cannot, don't have idea. Because the next date, I think, no, it's an order.
Lordship, this case.
Order of stay is there.
Yes, yes. Every month the date is given so far by Lord Mullis.
On the next date fixed. On or before the next date fixed. Indicating the witnesses it seeks to examine on its behalf. And thereafter, steps shall be taken for examination of defense witness. The learned court below shall endeavor to complete the defense evidence within a period of 2 months. Within a period of 2 months. And the court will see to it, that there is no delay in the trial of the old pending case due to any further within a period of 2 months. That will be sufficient. The interim order of stay stands vacated. The accused shall appear before the learned court on the next date. fixed. We don't know the date. The revision stands allowed and disposed of on the aforesaid terms. So would you like to pay some cost to DLSA? You can pay, why don't you? Pay some, can you?
Lordship, accused person is daily level, Lordship. Daily level, Lordship.
Oh, no use. True, that is also true. He's barely sustaining
Yes,
his
Lordship.
litigation.
Yes, Lordship.
That is also true. Anyway, no necessary.
Highly obliged, Lordship. Highly.
I think it's just two more matters. Very long.
Highly.
22. May I please, your lord? In this case, Honorable Court has passed an order. Other party has appeared, my lord. My lord, what happened, my lord? I take your lordship page 31 kindly. A complaint case was filed against the 9 persons, those who contemplating to purchase a plot of a flat booking flat, my lord, upon their own land, my lord. It was given to a builder.
So page
Page 31. Copy of the notice dated 5/5/25.
the criminal petition, right?
Yes.
31.
Whereas the complaint has been filed, the above noted case against you under 61, 22, 229, 3184, 336, 337, 339 of the BNS seeking some reliefs. You are hereby directed to appear before such and such date. And we have challenged it, madam. And Honorable Court has issued notice and state the further proceedings. And contemplated that they have appeared, madam. Our country is that under the garb of this, well, there is Supreme Court judgment, my lord. And there is a Muhammad Ibrahim versus State of Bihar, thereby held that court had time and again drawn attention to the following tendency of the complainant, attempted to give the cloak of the criminal offense to matters which are essentially and purely civil in nature. Obviously, either in the apply pressure on the accused or out of the enmity towards the accused to subject to the accused harassment. So, my lord, there is any dispute of civil cases are going on. Now he has filed this criminal case.
Okay. What is the complaint? Let us see the complaint.
Complaint is made at page
16.
Yes. 19, page 19. May I read? Page 19. Read. A big complaint, my lord. You can,
You can read, you can help, sir.
yes.
Read it.
Uh,
Let her read it.
On 24/1/8, the complainant purchased a plot of land measuring 1 katha, 1.6 lesser from the accused number 2, Benu Das, accused number 5, Deepak Das, and accused number 8, Dipankar Das, which was under the names and position of the situated under the Nagaon Sadar Revenue Circle, Dimaguri, Kisham Nishahar Moja, Patta number such and such, registered sale deed number such and such, subsequently matured in possessed in complainant. Additionally, for the purpose of the access to the said land, the complainant also acquired L-shaped pathway measuring approximately 11 feet wide and 250 feet in length through the registered sale deed from a portion of the land under pattern number such and such belonging to accused number 2 Benu Das. That on around 26/2018, with malicious intention and the undue greed, the accused person wrongfully dispossessed the complainant from the said land. Consequently, the complainant filed a case Honorable Court in Nagaon, which is currently pending. Special LG case number such and such, Honorable Additional District Judge number 2. In the said case, the accused appeared and filed their written statement. That from the written statement filed by the accused, the complainant came to know that all the accused person, accused number 1 to 9, by colluding with one another and the premeditated conspiracy to commit fraud, filed a collusive title suit being number such and such before the Honorable Court of Civil Judge Nagaon. Therein on 4/9/17, the accused person prudently obtained a compromise decree, very important, compromise decree misleading the court and suppressing the material facts. So the said compromise decree, this accused person included the complaint land and later encroached upon it. The complaint was completely unaware of the said collusive suit of the decree. In the said decree, it was mentioned by the accused themselves that total land of patta number such and such, jointly held by 9 accused persons. It is evident that the compromise decree was obtained illegally, fraudulently, and the misrepresentation thereby misleading the Honorable Court. Accordingly, challenging the said fraudulent compromise decree and for the consolidation of the land illegally claimed, the complainant instituted title suit number such and such, now numbered such and such, which is presently pending. That is, the title suit is pending. That special LG case number are sub judice, a builder group under the Royal Mansion Nagaon, commercial cum apartment promoter reliable associate NH Center Point, first floor, Borasarbi, Ulubari, Guwahati, a project knowingly, illegally and fraudulently with the intention of the deprive the unlawful profit, colluded the said accused person 1 to 9, initiated illegal and multi-story construction on the disputed land, patta number such and such. That on 30/1/23, the accused person along with accused number 10, accused an agreement for development of the land and irrevocable general power between such and such, wherein they fraudulently exaggerated the land area from the actual 1 biga 1 kata 17 hectares to 2 biga 1 kata by producing a forged and fabricated document, thereby misleading the Nagaon administration and obtaining fake approval from the Nagaon Development Authority, the circle officer of the Nagaon Revenue Circle, and the other concerned officers. The complaint was observing the ongoing construction of Royal Mansion going filed in RTI application and before the Nagaon Development Authority, and upon receipt of the document developed that the accused person illegally induced the complainant's land under the Kolong River and other lands of the project, forging valuable documents. The actual land number such and such, deed number is falsely shown to be 14 lesser. Even in some official document, it has been misleading, showing 2 biga 1 kata. Moreover, the written statement filed by the accused person in MJ case number such and such before the Honorable Additional District Judge 2 Nagaon, it is falsely stated that they possess 2 biga 1 kata of land under the patta number such and such. Hence, it is evident the Royal Mansion Nagaon commercial cum apartment and 9 accused landowners have conspired the deliberately inflated the land area number 1 biga 1 kata 70 lesser to 2 biga 14 lesser through forgery and fraud without complying the necessary legal formalities, including the Form 50, the executed fraudulent deed, obtained illegal building permission and other permission encroached upon the government land. The complained land and the commenced illegal construction. The accused persons by misrepresentation and the producing fabricated document are selling flats under the sale projects and collecting the money from the public, thereby committing large-scale fraud. As a result, not only the complainant already suffered irreparable loss, but around 90 families who have purchased flats in the same project, we are the all purchaser of the flats, my lord, we have booked, are also at risk of suffering permanent damages in the future. Therefore, the humble complaint most earnestly prays before the lordship that upon perusal of all relevant documents, a proper investigation may kindly be initiated against the accused person and appropriate legal action may be taken under the applicable provisions of law after examining the witnesses and verifying all related documents. So this is the complaint petition upon which the page 31 notice was issued upon us and we have challenged that notice, madam. And consequently, I am before your lordship, madam. Honorable Court has passed interim stay order.
You are for the complaint?
For the respondent number 2.
My respectful submission is that they
Do
are
we
not
have sufficient materials for adjudicating or should we have to call something? from the-
already trial court records are
It's come.
here. Yes, trial court records are here.
But the complaint case is at the stage of stay, no? Initial stage only.
Yes, initial
They
stage
were summoned
and
and it was stayed.
cognizance has not been taken
Not
as of
yet.
now. It is in a pre-cognizance stage as per the BNSS. So cognizance is yet to be taken. His stage at this present moment is even not as an accused, but notices has been issued as an opposite party. So it is a case of court has to consider whether there are prima facie materials or not. Let them satisfy before the learned court below that there are no materials. And as far as the documents are concerned, I have all the documents at my disposal to show how they have falsified and forged documents, starting from the RTA information which I have gathered, as well as the power power-of-attorney, as well as the agreement which they have entered with the builder. This will clearly show. I have all the documents at my
Civil
disposal.
cases are going on between the parties, madam.
That civil.
Now, why
civil-
criminal case is required? If
Because-
anything, they can, the only civil case, civil suit is the remedies,
Yeah,
that is going on.
There is a commission of criminal offense.
No. My lord, I have placed the judgment of the apex court, my lord, where the inherent power of the high court, quashing the FIR, complaint, criminal proceeding.
Let them
to act in
satisfy all
absence
these
of
things
such
before
inherent
the
jurisdiction.
learned court.
Your lordship
And
can,
in the petition also, I find that they refer to certain impugned orders, but I have not found any impugned orders in the petition. They have not even challenged a single order. The order, they are
that
showing
is the show cause notice that we
they are showing the show cause notice. At least they ought to have challenged that order.
TCR is there. Come.
Only because there are
no
some
criminal liabilities is there, my lord.
Only because
They
there
are going
there
to
are
the-
some pending cases between the
Right,
parties, that
that's
would not
why-
absolve them from the liabilities.
Because it all depends, that as we all know, so it's very experienced and we know that the criminalization of civil dispute cannot be done.
Yes, cannot.
That I
cannot
also
be done.
agree.
If it has a independent standalone
Yes, yes,
criminal dimension,
yes,
then it can proceed.
yes.
But for that, you have to see the materials.
Yes.
Right. So at the moment, on this petition, we have this only the complaint. Of course, the complaint makes allegations of forgery.
Yes.
Forging documents, as you say.
And these are subsequent to
No,
the
other
litigations which are
Let
pending.
us see what are the other documents. I can reserve it also and see it properly. This is land grabbing cases also there. This is
Yes.
That given so
That-
many cases, my lord.
Cases are pending, that is a
Pending.
fact, lordship,
That's a
and the other.
title suit is
Law will take
Respect
its own
is-
course. If you have done committed forgery, my
Yes,
lord,
yes, yes.
law will take its own course.
That course has to be
through the But why complaint is another petition which new is case? pending. Why is another new complaint? Because these are subsequent in nature,
No,
Lordship.
so this can be a new contention now, what
Yes.
you have said. This is a new contention which may be made that since pre-cognizance hearing is done, yeah, since
No,
pre-cognizance
not
hearing.
even done, notice has been issued.
No, since pre-cognizance provision has been made.
Yes.
So it is an additional layer.
Yes.
And so whether it should be quashed, suppose it is quashed, before that only, or should the trial court give an opportunity?
This is given, this
To place it-
opportunity is available. This is a statutory.
Parallel also.
Yes.
There's a blatantly, there is no criminal liability, then there's no need.
Because in the
to appear
in the
before-
complaint petition, exactly. In the complaint petition, the complainant specifically states that what are the documents available with him to show that he has committed some forgery with public documents. The RTI information as well as the power of attorney as well as the deed of agreement which they have entered with the builder. That Lordship they have stated that the actual land is 2 bigha 1 kata, but the actual land is 1 bigha 1 kata, Lordship. Well, for that, how That- there can be criminal that- case, they that- can go for that- injunction. That has to be examined by the learned court below. No, criminal Let- court cannot.
Let them satisfy. There is a
Criminal-
stage.
With the criminal
is-
complaint, it cannot be done. You
That
go-
stage- that
you
stage
file-
is-
You have filed a civil court, my lord, land grabbing case, my lord, cases are going on. Now, my lord, we have given the land to the builder. We
Yes.
have already booked the flats, my lord. Against that, they have come.
That stage is available to them under section 223 of the BNSS. Let
Anyway,
them
so-
satisfy the learned trial court.
Anyway, so let me reserve this. So I'm not feeling so well today, actually. So I'll read it at night today.
Oblige.
In 2-3 days, I will
Oblige.
dispose it off within this week.
Otherwise, remedy is
Perhaps
also available with them.
This was.
Remedy you have also come,
Ganguly.
but why you have taken this path of criminal liability? It is another way of pushing the pressure.
Arguments heard, judgment is reserved.
Oblige.
I'll see it carefully.
Deeply.
Last matter.
Well, at the stage of issuing notice in this matter, there was an understanding that the matter will be taken up for disposal. I don't think it may be possible to dispose of the whole matter. But the issue is, but otherwise very simple. If your lordship will first come to the FIR.
Just.
We have come against the, my lord, the petition for discharge was rejected. We have come against that. If your lordship will kindly come to page 31. At this stage, my lord, I would humbly pray that your lordship may perhaps examine the matter and stay this whole thing. I'm just pointing out the materials based on which the proceedings are continuing. This is the FIR. Madam. With due respect, I beg to state that as per the direction of the officer in charge of Tihu Police Station, I, Sri Paresh Chandra Das, is Sub-Inspector, along with the staff of Tihu Police Station, ASI Jiten Kumar, etc., so-and-so Sangma and Biju Roy, had proceeded for performing duties at the Sialmari Ansolik Bohagi Utsav, organized by so-and-so club and Sialmari Ansolik Bohagi Samaj, etc. While on duty, this is the allegation, while on duty at about 1 AM at night, an unknown person tried to snatch my service 9mm pistol from behind, but as the lanyard was attached with the pistol, he could not take it. Immediately after realizing the same, I apprehended the person, however, taking the benefit of the huge public gathering, the said person pushed me and fled away. Next one. Later on, I came to know from the local people that the name of the said person is Hitesh Aloy, son of so-and-so, so-and-so. Therefore, I pray that your honor may be pleased to trace out the said accused, etc. This is the allegation. Well, once the statements were recorded, if your lordship kindly comes to the statement, there's absolutely nothing to connect me that I am that person. If your lordship will first come to page 51. This is the statement of the complainant himself.
Here also he has said unknown person.
Unknown person. Unknown person, and last sentence your lordship will find. Later on, I came to know from local people that the name of the said person is Hitesh Aloy. This is the complainant himself. Then, if your lordship will kindly come to page 54. This is another constable. who was with him. My name and address given below, etc., etc. I am working in the battalion so and so. According to the instruction of the OC of so and so, I, along with SI Paresh Chandra Das, ASI so and so, went to perform the duty at the Sialmari Ansarik so and so. Around 1 a.m. at night, while we were having dinner, a person came and told us that someone tried to snatch the pistol of Paresh sir. Immediately we went there, but the person had already fled away. We searched for the people nearby, but could not find anyone. I did not personally see the act of trying to snatch the pistol with my own eyes. Now, my lord, if your lordship, down below, statement of another constable, if your lordship turns the page to page 55, he also says that he was having dinner and no one actually saw the incident itself. Exactly same thing. Page 57, this is even more interesting. Page 57, this is the statement of another witness. My name, etc., etc. Your lordship will skip to the fourth line. On that day, we were all busy with our respective duties. It was only the next day that we came to know that someone tried to snatch the pistol of Das. I did not personally see that. Identical situation with the next statement down below. It was, if your lordship turns the page, your lordship will find it was only the next day that he came to know. And then another statement is at page 60.
Translated, no?
Absolutely nothing to connect me, man. Absolutely on hearsay. And your lordship will kindly see the sections that have been 393, attempt to commit robbery. That is still understandable. They add 323, voluntarily causing hurt. It is the complainant's own case that it was only an attempt. Someone tried to snatch it from behind. And then assault, 353. How could assault even figure? Therefore, my lord, at this stage, I am praying that your lordship may examine the matter, stay the proceedings, my lord. There is absolutely nothing to connect me. No.
This, all the statements are here, no?
My lord, everything has been annexed. The lordship may call for the records.
Yes. All these vernaculars also have been typed. Hmm?
Yes, sir.
But this typed, this is a printed, it's nice. Good
Vernaculars are also annexed.
Next. Is there anything in the vernaculars to connect him? Otherwise, this
Absolutely nothing more.
we have already seen this. Zone Manhoy. Anyway, Mr. Boysa.
Yes, my lord, my learned senior has already submitted, my lord. That is it is a FIR, my lord, which is laws on 23/5/2023, my lord. The allegation is very serious, my lord. There is a policeman, my lord, while he was, my lord, discharging his duty. Allegation is that some unknown miscreant, my lord, trying to, my lord, snatch his, my lord, pistol. That is the case, my lord. Time is, my lord, 1 a.m., my lord, after midnight, my lord. That point of time, during a, my lord, when, my lord, Bihu function, my lord, there is the festival is going on. At that point of time. My lord, thereafter, my lord, the investigation was, my lord, completed, search sheet file, my lord. This FIR is dated, my lord, that is 23/5/2023, CS dated 23/6/2023. During the course of investigation, my lord, 10 numbers of PWs were examined, my lord. Now, my lord, here, my lord.
What was contended, the learned counsel is that.
Yes, my lord.
The main issue is of identity.
My lord, main issue is identity. I'm getting, my lord, that point. Now, my lord, that is, my lord, whether, my lord, this honorable court, my lord, at that point of time, my lord, to find out who is the identity of that person, my lord. It is the circumstantial evidence, my lord, which will, from that where it will come out, my lord.
But
That is the 161 statement, my
But
lord.
if none of the witnesses, throw light on the identity.
Yes, my lord.
Then he may have some case. Then
Yes, my lord.
he may be justified in seeking discharge.
Yes, my lord.
Right?
My
Per se.
lord, for that reason, my lord, I am again coming to the, my lord, there is the statement, 161 statement, my lord, recorded, my lord. That is by the informant, my lord. Informant, that is page 53. I'm going to the, my lord, vernacular part, my lord. That is page 53, my lord. Statement of complainant, Paresh Chandra Das.
53.
Yes, my lord. Page 53 of the petition, my lord. Yes, may I read out, my lord? Only the relevant part, my lord. মোৰ নাম আৰু ঠিকনা ওপৰত দিয়া মতে সত্য মই টিহু আৰক্ষী থানাত উপপৰিদৰ্শক হিচাপে কৰ্মৰত যোৱা 13/5/2023 তাৰিখে মই টিহু থানাৰ OC ছাৰৰ নিৰ্দেশ মতে ASI জিতেন কুমাৰ 4th APTF কনষ্টেবল 6 সোয়েনচোৰ সহ মহাবাহু ক্লাব আৰু আঞ্চলিক বহাগী সমাজ কল্যাণ সংঘৰ উদ্যোগত শিয়ালমাৰী আঞ্চলিক বহাগী উৎসৱ কৰ্তব্য সমাপন কৰিবলৈ যাওঁ কৰ্তব্য কৰি থকা অৱস্থাত নিশা প্ৰায় 1 মান বজাত পিছফালৰ পৰা এজন অচিনাক্ত ব্যক্তিয়ে মোৰ সাৰ্ভিস 9mm পিস্তলটো কাঢ়ি লৈ যাবলৈ বিচৰাত পিস্তলটোত লগাই থোৱা ৰছীডালৰ বাবে নিব নোৱাৰিলে লগে লগে মই গম পাওঁ আৰু মানুহজনক থাপ মাৰি ধৰিবলৈ চেষ্টা কৰোঁ যদিও উৎসৱস্থলীত থকা জনতাৰ ভিৰৰ সুযোগ লৈ মুখ ঠেলি মাৰি মানুহজন পলাই যাবলৈ সক্ষম হওঁ Now my lord here the words that is my lord in the my lord statement is used that লগে লগে মই গম পাওঁ আৰু মানুহজনক থাপ মাৰি ধৰিবলৈ চেষ্টা কৰোঁ Now my lord লগে লগে মই গম পাওঁ থাপ মাৰি মই মানুহজনক ধৰিবলৈ চেষ্টা কৰোঁ meaning thereby my lord I see the complexion of the people my lord I cannot say my lord that is unknown person my lord that is the case of trial my lord from that my lord everything will come out whether I have seen the person or not my lord লগে লগে মই গম পাওঁ মানুহজনক থাপ মাৰি ধৰিবলৈ চেষ্টা কৰোঁ যদি উৎসৱস্থলীত থকা জনতাৰ ভিৰৰ সুযোগ লৈ মুখ ঠেলি মাৰি মানুহজনে পলাই যাবলৈ সক্ষম হয় পিছত স্থানীয় লোকৰ পৰা জানিব পাৰোঁ যে মানুহজনৰ নাম হিতেশ আলয় it is not my lord from that my lord he tried to my lord snatch the person my lord somehow he escaped my lord later he came to know maybe by dint of my lord there is complexion all my lord police may come to know my lord now my lord
They could have done TIP. They did not.
my lord that part is also there my lord yes obviously my lord and my lord that is the second part my lord there is a statement of the witness ASI Jiten Kumar my lord মোৰ নাম আৰু ঠিকনা ওপৰত দিয়া মতে সত্য মই টিহু আৰক্ষী থানাত চিৰাস্তাৰ হিচাপে কৰ্মৰত যোৱা 24 তাৰিখে ইমান তাৰিখত মই মহাবাহু ক্লাব আৰু আঞ্চলিক বহাগী সমাজ কল্যাণ সংঘৰ উদ্যোগত শিয়ালমাৰী আঞ্চলিক বিহু উৎসৱত কৰ্তব্য সমাপন কৰিবলৈ যাওঁ নিশা প্ৰায় 1 মান বজাত আমি ডিউটি কৰি থকা অৱস্থাত দেখা পাওঁ যে পৰেশ ছাৰৰ পিস্তলটো এজন মানুহে কাঢ়ি নিবলৈ চেষ্টা কৰিছে Now my lord he was very much there this person and my lord that is his statement my lord পিস্তলটো কাঢ়ি নিবলৈ চেষ্টা কৰিছে লগে লগে আমি মানুহজনক ধৰিবলৈ চাওঁ যদিও ইতিমধ্যে তাৰ পৰা পলাই গৈছিল আমি ওচৰে পাজৰে মানুহজনক বিচাৰিছিলো যদিও বিচাৰি নাপালো এইখিনিয়ে মোৰ ক'বলগীয়া my lord these are the two statements my lord
And the others have also stated on similar grounds.
Others
some
are saying
hearsay,
that
my
they were having dinner somewhere else.
My lord, others are, most of them are hearsay evidence, my lord. The admitted position, my lord. They
Let's hope,
hard.
Because this is certified copy, but still you can call for.
Yes, my lord. Yes, my lord.
Justified.
Yes, my lord. Yes, my lord. Yes, my lord.
Because see, the thing is that in charge, as we know.
Yes, my
There is
lord.
also this grave suspicion test. If there is no grave suspicion,
Yes, my
you
lord.
can. That flexibility is there.
Yes, my lord. My lord.
But here, in fact, if all the statements are on these lines, then the question of identity
Yes, my
becomes
lord. For that reason, my
difficult.
lord.
Suppose they come, suppose,
My
you know, on these statements, suppose they come in the trial and say in the court that, that we saw, you know, that I know the person, that will be an improvement.
My.
So, because.
My lord,
you
my
know, because the foundation will be in the investigation.
Yes, my lord.
Anyway, so, thank you. ঠিক আছে। But once the records come, it can be disposed
Yes,
of. No need to fix it for hearing. Let it remain in admission only. Third, not senior counsel, I showed. Hearing form assisted by the instant application has been filed under 528 BNSS. And so agreed by the order dated 6/6/2024 passed by the learned JMFC Tihu Nalbari in PRC 37 of 2024, whereby the prayer of the petitioner, kindly have a seat, I take 5 minutes. Prayer of the petitioner seeking discharge in the case was rejected. Full stop. It may be mentioned herein that an FIR dated ... was filed by police official Paresh Chandra Das against the present accused the present petitioner with the allegation that on the day of the incident, that is 13/5/23, while he was on duty in connection with a Bihu function, one unknown person tried to snatch his rifle, but it could not be done so. Service weapon, service pistol, but it could not be done so as it was strapped. And later it came to be known that the petitioner is the same assailant. The learned counsel has taken the court through copies of the statements of witnesses annexed to the petition and contended that none of those statements have stated about the identity of the person in any direct manner, and that any ingredient of the statements pertaining to the name of the present petitioner is only by way of hearsay. The learned counsel seeks stay of the proceedings. Also heard learned additional PP, Mr. Boysa, who submits that aspect of identity might be a matter of trial. Nevertheless, call for the scanned. What do you need? We don't need the whole recording.
Yes,
We
ma'am.
need only the relevant parts.
Yes, my lord.
The statements. just a
Statement is
replica of what he has given.
only, my lord, that is the CD part, my lord.
Only for the
That-
procedural.
That part is enough, my lord.
CD and charge sheet.
Yes.
Scan copy of the case diary and the scanned charge sheet. Full stop. In the circumstances. I find sufficient force in the contention, in the prayer of the petitioner side for stay of proceedings according. Further proceedings in case number, PRC number so and so. Pending before learned JMFC, Tihu, Nalbari, shall remain stayed till the next date of listing or till disposal. Well, till the next date of listing, next date of listing. This is the matter, and you can suggest a date, both sides can suggest a date. To go to Arunachal also.
19th of November.
No, 1911.
Right.
Arun.